listed today.
Let it reach. Let it.
Item 1.
Challenge. The main award is not before us. Challenge against the main award is not challenge, right?
Yes, challenge.
Main award also.
Yes, yes.
This is decision on it. By the way.
Sorry, he was mentioned. Dr. Singhvi, you were saying something? Sorry. When it comes out, both of you are agreeable, we'll dismiss as withdrawn. But let it come, let it come. It's okay, somebody will be there. Mr. Diwan,
Yes. So, my lord,
you
may I
challenge the main judgment also.
Yes, yes.
On what ground?
Yes, so let me just tell you the impression. Just let me just.
No, I mean, only short question to you is.
Yes, of
you will
course.
Anyway, go in your own
Yeah,
way.
yes.
Is it that in the 37, you have
Yeah.
challenged the validity of the award? Is it open or is it confined only to whether the interest should be compound or interest should be simple?
No, see, I'll just, there's a wider issue over here. So I'm going to just indicate what has happened. I'll give you, but first, since the question is being put to me as to what are the issues, may I indicate the issues first and then give you the background?
It's raised in the context of understanding how long it's going to take.
No, it will take a little while, Manoj. It will take a little while because it's a very important issue at 4 or 5 levels. The first is we are faced with a 138 crore award today.
Makes no difference.
Sorry?
Makes no difference.
No, it may make a difference to the court because this is a case where when the pipe.
What's the issue?
Yes, so I'll just indicate what the issue is. So then can I just give you what my points are? I am going to be raising and urging your lordships to that there are several jurisdictional issues which arise in this case. Jurisdictional. Now, what is the first? I'll enumerate them. First jurisdictional issue was that the time of the arbitral tribunal was not extended by.
So our judgment just now pronounced covers the issue.
Yes, it probably does. So we'll be relying on.
No, it's on 29A, 5 and 4. That was a situation where the time had expired.
Yeah.
Even the extended time under subsection 1 as well as subsection 3 of 29A
Yeah.
had expired. And before the court, before even an application for extension of time was made, award was delivered. So the question is, in a case where award is delivered, can the court extend the time was the question. We have considered it comprehensive.
That's the one rendered today?
Just now.
I see. So I haven't had the advantage of looking at that. But I might tell your lordships, if you feel that has a bearing, then we will obviously have to study it. But I might just indicate what our situation is. Our situation is that the agreement.
Is this the same situation here?
No, it's not.
Award is award.
Different. Sorry, the award is rendered.
When the time under 1 and 3 had expired.
Yes. So
there is no mandate for the arbitrator.
Yes.
You are right.
This is a yes, it's a pre-amendment situation. So we are concerned with a situation in our case where the agreement itself prescribed a period.
Okay.
Parties mutually extended the period from time to time. Eventually, when the arbitrator, arbitrator had also extended it suo motu himself. Keep that aside. We then extended the period. Thereafter, when the final extension was sought, we said, sorry, we are not agreeing to this particular extension. Despite that, the arbitrator went ahead and delivered the award.
It's an issue which needs to be considered.
So that will be an issue which needs to be considered. Second issue which needs to be considered, very, very important, according to us, is with regard to review. So let me just explain what happened there. The arbitrator passed a award where he granted simple interest.
In review, they have
expressly. He also made a suo motu correction to that award.
But now it's covered under Gayatri Balaswamy.
Yes, Gayatri is important. So thereafter, my lords, he makes a small correction, but he doesn't correct this material part. The other side, which is the award holder, goes by way of a 34 read with 33. That comes to be dismissed on merits.
We know that.
Now, once it's dismissed, my lord,
grant leave in the matter.
I will then only ask for a short
grant leave in the matter.
Just,
leave granted.
Lordship will just give me a minute.
Leave granted. Hearing expedited. We'll expedite the hearing.
My lords, we've been waiting for.
Acha, what?
He's in his late 80s.
Mr. Diwan, have you deposited? What's the position?
Yes, what pursuant to the directions of the court, which is 5 crores, we have deposited. And look, I mean, I'm just stating this because I'm backed by instructions. If we are right, we may not be right, your lordship may dismiss our application.
Entirety of the award amount.
It's 130.
Award amount is how much?
1 crore on the date of the award. 1 crore was the amount.
With simple interest?
With simple interest about 50,
4 crores.
4 crores.
So the compound interest makes it 21 crores.
130.
130 odd crores today. And I am the Gujarat, my lords, water supply and sewerage board. I will have no money for laying a pipeline. If this is, and this is for 99, 2000, I'll give. No, my lords, I want to, your lordship is granting leave. I'm grateful for that. I'll only request an expedition. I'm just making a suggestion with prejudice to my submissions. If we are right eventually, of course, the whole award will have to go, if we are right. But at the moment, my lords, without prejudice to rights and contentions, the amount which we have deposited and which they
How much have you deposited?
6.
5 plus
5.
5 plus 1.
We paid 5. The person to interim order.
How much have you deposited totally?
There is no deposit line with the.
There is nothing now lying. my lord.
Okay, six.
Please, the order.
6 deposited has been withdrawn.
6.
Where is 6? Where is 116?
It's 5 plus 1, my lords. I'm instructed 6 crores. It's
Okay,
reflected in your
pending
lordship.
disposal of the appeal, the entirety of the amount deposited can be withdrawn by the respondent.
They have withdrawn. They have withdrawn. Well, we don't mind closing the matter at this.
6.
At this.
No question, no question. How can you
No,
close it?
no.
We'll have, your points are not absolutely, we can allow it. They're subject to.
No, of course. Then the whole thing
case.
comes back. If the award is set aside, it will come back. I'm just saying these are supplies which were made in 99 and 2000.
Is it an MSME?
Yes, it's an MSM. So I want to tell your lordships that, my lords, for 12 years they didn't initiate arbitration. There's an arbitration agreement of
Against
2012.
an award now. Anyway, a hearing expedite. Post-
Hearing expedite.
Please.
May I say
April.
something, sir?
April.
But my learned senior trainer. First thing is there was
So, okay, we'll hear you. We'll hear.
extension by what conduct the parties.
Yes, yes,
That's
you are right on that.
Yes.
We are not against you. You may be, because before the amendment, it's permissible for the high courts to, or the arbitrators to draw a 34 and 37 court to draw an inference that there was implied consent. There's no problem.
There's
We'll be aware-
this
we'll be
in
with
the
you on
judgment itself.
We'll be with you on that. We'll see.
So
Great.
only humble request is that my client is 83 years of age.
We have expedited.
Please.
Great.
Item 2.
These are final.
Sir, I'm requesting for a passover. Please, my lord. My lord, I'm requesting for a passover.
Hey, come on now, what passovers?
My lord, the arguing counsel.
All long. Amendment. It's only an amendment. Tell us what.
My lord, the arguing counsel is on his leg.
You argue, you tell us. It's
Uh,
a simple case where 2 amendments were made during the pendency of the appeal, and those amendments were allowed. The revision is dismissed. So we can ask the High Court to expedite the hearing. Why should you contest against an interim order?
My lord, let the arguing counsel argue this case.
We'll allow it.
Just a passover.
What time is?
The covered case, my lord, have already considered this issue, my lord.
No,
There was
doesn't
only
matter.
amendment to the prayer clause.
But this is interim in nature.
Yes, my lord. In fact, they were compensated with costs also.
It's an amendment to the relief clause only, Honor. Adding the relief of possession. Only the relief of possession has been added to the
No, my lord.
nature of the
My
suit
lord have
doesn't change,
already
my lord.
considered this, my lord.
There is a identical
Exactly-
decision
Exactly same issue.
allowing the addition of the relief of possession at the first appellate stage.
Initially, it's a suit for civil injunction.
It's a suit for injunction
Now
But-
your IA is for possession now.
for possession, but the reason for that is that the learned trial,
But then not at the trial court stage. You have lost in the trial court, in the
Trial
first appellate court. At the
First
first appellate court, you are filing this application.
we are filing
2017,
this
your suit is of 2015.
suit is of
And
2015.
2017, your suit is dismissed.
Yes.
And then
Yes,
at
my
the appellate stage that you come up with these applications in the year 2022.
This is, I would like to draw your attention to an identical judgment.
No,
Passed by
one
the
more
Honorable
this
Supreme
thing.
Court.
The,
What is it?
another problem is that you have
Listen,
been
brother.
non-suited by the trial court on this very ground that you did not seek the relief of possession. So the another question would be whether you can be allowed to fill up the lacuna at the appellate stage. You have lost the suit on this very ground
My lord, this
that
is,
you didn't claim the possession.
the decision of the suit has not been made on merits.
This is also a case where it is a appellate stage amendment.
This is a case where, my lord,
Appellate stage.
appellate stage application for adding the relief of possession. Suit was dismissed on the sole technical ground that the prayer for possession has not been made in the plaint, and the plaintiff has not been found to be in possession.
Which para?
So I'll invite your attention to, this is, first of all, page 3, my lords, para H. Also appears that in the first appeal filed by the LRs of the original plaintiffs, an application for amendment of plaint was filed. I beg your pardon. Subpara H, my lord, page 3 of this judgment.
Read it.
Yes,
also
it also
appeared-
appears that in the first appeal filed by the LRs of the original plaintiffs, an application for amendment of plaint was filed, wherein the plaintiffs prayed for possession of the suit property. Application seeking amendment of plaint filed by the LRs of the original plaintiff came to be allowed by the first appellate court, and the plaint was accordingly amended.
What happened in the trial court? They dismissed the suit on
Yes,
the ground
yes, Lord.
that
They dismissed the suit. Para, may kindly see para 22.
all right.
Para 22, my lord.
Have you seen this Gagan, this judgment?
Yes, my lord. I'm
Ours-
sorry, I'm late.
Doesn't matter.
This para 22 summarizes the whole main issue involved in this,
Suit was
in the ratio.
executed, Suit was, on what ground was the suit dismissed?
Relief of possession was not.
Oh, same.
Same ground.
Yeah.
same. Suit dismissed on 6/9/14
Amendment in 2014. Acha, during the pendency.
during the pendency.
Amendment.
Application for amendment. There's no change in the nature of the suit, my lord.
My lord, just give me 2 minutes. I'm sorry, I'm late, my lord. I was in an item 1 in the adjoining court. Only 2-3 things, my lord. One is, my lord,
Even otherwise also, irrespective of the judgment, but then I think it takes a rather
Just give me 2 minutes.
liberal view.
just give me 2 minutes since your lordship issued notice, my lord. Just give me 2 minutes. The first submission is that before filing of the suit, my lord, they take a local commissioner's report. On their application, the revenue officer reports that I am in possession. They file that report with the suit, my lord, and still file a suit only for injunction, not for possession. That is the first submission.
All that will be merits of the matter which you may address.
No,
Because we are on rather, we were, what impressed us
yes.
was the maintainability or rather abuse of the process.
So therefore, 4-5
But I think
submissions.
it's,
4-5 submissions.
Or the second,
bullet wise,
second,
my lord.
second,
The second submission is they allowed the suit to go on. The learned trial court dismisses the suit, my lord, since it is only for injunction, since I am in possession.
correct,
In the first appeal, they now seek to amend their plaint.
correct.
That is, my lord, the second submission.
Third,
Now, please see the amendment application. My lord, an amendment application in a suit would also have to plead due diligence and overcome the bar of, my lord, proviso to 617 post-trial. Now, we are in first appeal. Can I show the amendment application to your lordship, my lord? Due diligence, my lord, is the first ingredient. So, please have the amendment application, my lord, at page number 168. 168, I will read, my lord. 617, I did not tell your lordship, my lord, due diligence is the first, my lord,
Yeah.
ingredient. Please have 168.
two courts have taken a view. We won't take a third
No,
view.
no, the trial court decided in my favor.
No, thereafter.
No, the first appellate court has dismissed their amendment application. So please have
Division.
168. Please have 168, my lord. Lord, before your lordship allows an amendment application, due diligence at the cost of reiteration laws is the first ingredient.
So,
Why they did not plead earlier? Here, my lords, I have stated in my written statement that I am in possession. So please have 168. That's an application for amendment of the plaint in a first appeal.
You see, one point may be in their favor, another point
Yes, my lord.
that they have undertaken not to adduce any evidence. So whatever it
What
is.
balances it?
So therefore, the
Correct.
third point.
Now leave it.
No, no, let's two more points.
Having considered.
Two more,
the
no,
matter
not on
in
merit.
detail and
Let's two more points, not on merit.
Go.
Not on merit.
No, Gagan.
Not, Lords, not on merits. I'll be prejudiced. Otherwise, I wouldn't have insisted. The third point is 2 to 7. Lordship, if your lordships have lords. Now the fourth point is, please see the impugned order. I'm not saying reverse the order now. Your lordships have dismissed my 3 points. But the fourth point is, please see the impugned order. If somebody is being allowed to file a lord's amended plaint, am I not allowed to file a written statement? And the matter has to go to trial again. Lords, I will be prejudiced.
Just
They
to
may say,
play
1
of
minute.
possession.
They may say I will not lead any evidence, but I have to lead evidence. If they amend the plaint, I have to
Then
file an
what is
amended
their
written statement.
position? Hardly. Now.
No, no, Lords, am I not
Okay,
allowed
we
to
heard
file a written statement to an amended plaint?
The learned counsel for the petitioner, and we are not inclined to interfere with the order, particularly in view of the approach adopted by this court in the case of Mallava and others versus so and so, so and so. Footnote me laga dena. You want us to direct early disposal of the suits?
And now, my
Suit
lord,
is before
therefore, I
the
just said, just give me.
First
We
appellate,
are at the stage of first appeal.
first appeal.
The trial court had dismissed the suit.
Yes.
Now, what does the interpretation of the impugned order, lordship may kindly
It is,
tell?
it
The
is-
impugned order says that I am allowing you to amend the plaint without saying anything else. So my concern is, my lord, if the plaint has been amended, it has to go back to the trial court.
Need not go to trial. First
Lord,
appel.
Just
First
the
appellate code is an.
addition
But
of
I
the
have to
relief
put the
clause.
written
where-
statement, my lord. They just can't say that for 5 years I will not amend the plaint. Now I will amend the plaint and the appeal will be heard on the
Right.
amended plaint.
See, it's not such a major amendment.
I am in, I have to, now it becomes a suit for possession. I have to, my lords, defend it.
They can manage in the first appellate.
It is a suit for possession. I'm sorry. No, no, my lord,
If you
lordship
want
may
to,
direct-
if
lord-
you want to lead evidence, apply before the.
But unless I amend my written statement, my lord, whenever your lordships
course.
allows amendment of plaint,
Of course,
You apply.
consequential amendment.
the Honorable High Court does not say so. I will be prejudiced. Lordship may observe it, my lord.
Yes, yes, of course.
Yes,
I mean,
lots
it
may
goes
observe that.
without saying that once one party has
It
been
didn't
allowed.
bar you. It didn't.
My
bar
lords,
you.
it does. And
All right,
I
now.
have given that ground.
Now, Gagan, leave it at that. Thank you.
The lordship may at least, my lords, give me permission to file an amended written
Without,
statement.
without prejudice to such rights and contentions as the respondent may be entitled to under the Act and the rules. CPC, obviously.
Including the right
In
to
law.
file amended
In
document.
law. In law.
Lords, including the right to file the,
We'll,
still saying no, no.
keep it
Lords, you
open.
will not allow me to file an amended document.
He is not.
That's the obvious reaction.
Neither he will go there nor you will go
Then a
there.
trial court will say the Honorable
Okay,
High
with
Court
that
has
now.
now merged in the Supreme
Now,
Court.
now you should stop after we pass.
As your lordship.
Next.
Deeply open.
Please, your lordships.
A for injunction.
The High Court granted some interim injunction.
We granted this.
Your lordship were pleased to grant interim in order, my lords,
3.1.
in 2 matters, both the matters.
So therefore, there is an interim order here since.
Yes, yes, by your lordship court since quite some time, and suit is pending for consideration.
Why don't we do one thing? We'll continue this interim order
Yes, my lords.
and then ask the suit to be disposed of,
Expedite.
because that seems to have prevailed.
In that event,
Ah.
there will be time limit, my lord.
Yes, yes, sure.
Of course, my lord.
You are very right. You are very right. Pehla first paragraph is against interim orders. Hold it, na? First paragraph you quote kar lo. And during the pendency of the special petition, this court, by its order dated 24/1/2025, direct.
And also, my lord, another order by your lordship court on 9/4/25 in the other SLP. 9/4/25 is a better order, my lord.
24(1) is in 3.1, where I appear.
In so
And item 3 is, my lord's, order of 9/4/25.
that order is at 9/4.
Status quo, my lord.
Okay. A similar order
Similar.
has been passed in the other connected matter, which is as karke quote kar lena, in view of the fact that the interim order, interim directions issued by this court on 24/1/2025 and so and so, we appeal that the interests of justice will be subserved by confirming the said order and requesting the trial court to proceed with the suit. Full stop. Yeah.
Title suit number 95 of 2020. Right.
In view of the above, appeal is allowed, leave granted, appeal is allowed with the above directive. That's it.
Please, your lordship. You wish to oblige.
Well, let there be a time limit, my lord.
Okay. This is a suit of which year?
22, my lords.
22.
T2. Okay. There shall also be a direction to the trial court to take up and dispose of the suit as expeditiously as possible Preferably within what, 1 year. 22 suit is too early to say.
No, my lord, we are prejudiced.
As expeditiously as possible.
Lordship.
Yeah, right. Next.
Remains to apply.
Any time limit, my anything that may fall from your lordship.
We said as expeditiously. It's a very strong word.
Great.
Next.
Item 4, your lordships, may I request for a passover? Item 4,
Passover, what Passover?
plus the arguing
Tell us,
counsel is before the other.
What is to be done? It's about, he says that there is a contempt.
Yes, my lords.
How is it a contempt anyway? He
Well,
has to answer
My
it.
lords,
I move this application. Against
my lords, I'm just requesting for a passover, let it be heard.
rejected our compliance.
We finally heard thereafter, my lords, pleadings are complete.
No, it's not a contempt. Passover, man.
Let it be passed over.
Mullins,
You think?
Mullins, we have complied. I don't know what lies for contempt. We've rejected it with detail.
We granted you an interim order.
We have. Do we have
Yes,
any time?
yes.
Mullins, they take it up next week, Mullins, because I do not know where the second argument. It's today is Tuesday. It's a heavy board. Mullins, next Tuesday, Mullins, I'll be there.
Next Tuesday, next Tuesday.
Next. Obliged. Please, Mullins.
ऐसे कर लेंगे.
Obliged.
Was the very surprising. I must state
Nowadays, all these days, everybody wants to have
an interesting
main reliefs through contempts.
and not even the main relief. Not original order is of 2012 pertaining to the acquisition proceedings. This is about that Anna Sagar Lake in Ajmer, where illegal constructions are there. NGT multiple times said, please, these are the illegal construction. 2012 order was in case of section 4 proceedings saying that don't dispossess. We are not
Don't
dispossessed.
dispossess, okay.
The issue was that on agriculture land, you can't make hotels and the banquet halls under the state, under the act.
Which is that order which initially they passed an order,
Well,
the 35, you issued a notice.
well, the first,
Then they filed a miscellaneous application.
we withdrew that notice. The
You
proceedings today
withdrew
are
that
not.
notice.
Yes.
And then you gave the 23rd October 24 notice of a seizure notice.
Well, three things we did before that. We issued a show cause notice on 1/10/2024, page 35.
Yes, show cause notice.
Yes. Then page 35.
Correct.
So after that, they replied.
They filed a IA.
Yes, they filed IA. We passed the order on 22/10/2024, said that your construction is illegal because you have never changed the land, never plan approved.
The appeal against that is dismissed, right?
The appeal has also been dismissed. Now the Honorable Court in a proceeding of 2010 says that every proceeding which the state has to take under the act, you come to me and seek permission. How can
2010 is that acquisition.
Oh, this was related to acquisition.
But this is completely unconnected, actually.
And they've
Kindly peruse the page number 3 of the MP's order. They have given consent.
no, I think I'll answer that also.
Okay,
Kindly
see
see.
what consent, just read it.
Yeah. Para number 6, taking into consideration the undertaking submitted by the petitioner counsel for appealing for the respondents, it means ADA, on instruction from the officers of the ADA state, they will issue the order of releasing the land in issue within a period of 1 week. I have given undertaking that I will not
That's
carry.
okay. That release got nothing to do with contempt. 1 minute. That release is in the context of the acquisition proceedings of 2012.
In the contempt matter, they have given undertaking, your lordship.
You arm twist, so what will you do? You do these arm twistings and what will you do?
And I have given undertaking
this
that I will not carry any activities. I have also given undertaking in written form that I will not carry any activities on account of that undertaking. They have.
But anyway, tell us one more thing. What happened so far as 10th July 2025 order is concerned? Where your appeal is dismissed?
No, lordship.
What happened to that order?
I have given.
You're not answering our question.
Only simple application. That was not appeal, your lordship. That was not appeal. It was a simple application to deseal my premises.
Page 48.
The appeal. Kindly see your lordship.
48.
The present appeal case.
Yeah. Page 48, your lordship.
Appeal number
What
at the
happened
top.
against that order?
Yes.
What have you done?
I have-
Retained finality or not?
No, lordship. Kindly peruse the page number 49 of that order, your lordship.
Just read that order. That's an
Yeah.
appeal.
Kindly see.
Read it and tell us. That's an appeal filed by you.
It's not a, it was simply an application to deseal the premises. There was no provision of appeal, your
No,
lordship.
there is.
There was no provision of appeal because,
See that, read it carefully.
yes,
Appeal ADA, case number so and so.
yeah, yeah,
Signing off.
they have mentioned,
Appeal case is, anyway, against this order, what have you done? What's the direction in this order? Just see last portion.
Last page.
Therefore, as regards the above facts and the overall consideration, no, regarding the ownership of the disputed
Yeah.
appeal submitted by the appellant under section 35A
page 49, your lordship. Kindly see, page 49.
being
The appellant carried out commercial activities on the said land without obtaining prior permission of the authority without land use conversion. That was the crux.
dismiss हो गया ना?
Correct. It's dismissed. Page 50.
Yes. इनको dismiss हो गया. Then what remains of, we are concerned not with your rights so far as the acquisition of the property is concerned. We will not touch upon that. We will exercise your rights with respect to the legality and validity of the acquisition. But so far as proceedings initiated under the Act for unauthorized constructions and seizure and other things, these statutory provisions have to be continued, even assuming that you are an owner, right?
Absolutely.
If you are an owner, then you will have to abide by the municipal laws. They have issued show cause notice to you. They passed an order about illegal construction and for removal and for seizure. You appealed against that order. That appeal is dismissed. So you must avail alternative remedy against that. In the meanwhile, the question of contempt doesn't arise. This is all that we are saying.
But please, your lordship, they have given undertaking that I will not carry that I will not carry any commercial activities on account of that. They were ready to deseal my premises, your lordship. Undertaking has been given by them, your lordship. Undertaking has been given.
Well, I clarify. The issue was, and I took this instruction because originally we said we'll not.
This is 2012 writ petition is that acquisition.
It's yes. So we said in context to that, we'll not dispossess so far as there.
Also not contradictory.
Absolutely. Well,
That even assuming you are owner, you will have to abide by the municipal laws.
how can they stop the wheel of the act?
Okay, leave granted, leave granted, leave granted. Leave granted. First para लिख लेना.
And contempt has not challenged the order, your lordship.
Contempt is between us and the contempt norm. It's not so much about the High Court impugned before us, directed that recorded an undertaking of the appellant authority and further directed that Para 8 में है that the authority shall proceed. What is that? Sealing, is it?
Yes.
Can take action only upon taking permission of the court in writ petition number, consent and permission of the court in writ petition number 13476 of 2012. 2012 full stop. Their paragraph. The above said the said writ petition is filed by the respondent challenging the acquisition proceedings, and in the said writ petition there is an order of status quo on 8/10/2012 full stop. Pending paragraph, pending disposal of the writ petition, appellant authority had initially invoked proceedings under section 7, which were 67, which were for encroachment, which were later on withdrawn. Thereafter, they issued notice, a show cause notice under section 35, which came to be challenged by the respondent before the competent authority, and which culminated in an order of a sealing order dated 23/10/2024. The respondent also filed an appeal against that order, which came to be dismissed on 10/7/2025. It is therefore, it is also clear that the order dated 10/7/2025 had attained finality. It's therefore clear that there's no occasion for the respondent to initiate contempt proceedings against the petitioner, against the appellant, on the basis of the interim orders passed in writ petition number so and so dated 8/10/2012, We are of the opinion that the proceedings initiated by the appellant by the respondent for against acquisition of land stand on a different footing from that of the proceedings initiated under the Ajmer Act,
Ajmer
under Section
Development
35
Authority
of
Act
the
2013.
So in fact, under charge. As challenge to the show cause notice dated 1/10/2024, leading to order of sealing culminated with the dismissal of the appeal on 10/7/2025, year of opinion that no contempt, that there is no deliberate disobedience of any of the court's orders. In this view of the matter, initiation of contempt is uncalled for. The order impugned is therefore set aside.
As I'll just humbly request,
Our-
Lords can clarify.
Liberty
One-
kindly be given to assail.
No problem.
To assail the remedy against the 10th of Black.
Based,
We'll do that. We'll do that.
based on para 8, multiple petitions have been filed in the High Court saying that the High Court sought you seek permission. Just kindly clarify that these are independent proceeding. If the
They have already said it. They are independent.
no, but because what they say is court says for if you want to take any action, please seek my permission.
We have
That's in
set-
para
we have
8.
set aside this order. What more is there? We have
Well-
set aside completely this order.
I'll request if my lords can at least observe the independent of this, if any violation.
Already said it.
Very well.
We
Very
have
well.
said that they are unconnected.
Liberty may kindly be given.
Very well.
We make it clear that the respondent is entitled to adopt such remedies as may be available to him in law to challenge the order dated 10/7/2020.
Grateful.
These observations, the appeal stands allowed.
Great.
Item 6.
They have to finally rejoin the reverse case as they prepare.
Appearing for the state of Bihar, Lordship.
Who is appearing for the increase in the number of sawmills is covered by some of the orders passed in the Godavarman case. Has anybody examined that?
Also, on the last date, the union
told you
has been
also.
directed to file
Yes,
affidavit.
yes.
Affidavit, but I can.
Don't need any affidavit.
Yes, Malaj. In fact, TN
Just
Godavan,
tell us, sawmills orders, lots of orders are there.
it is Malaj for the state. The state, we have provided the guidelines 2019 as well as they were amended also. The broad policy framework is already there. The state has to now take into.
We will dispose of this petition.
Yes, Malaj, because.
By saying whatever is the law with respect to
Yes.
opening up, monitoring and continuation of sawmills are concerned, those provisions must be followed.
Yes.
That's it. Huh?
Because Malaj, ultimately the state has to see how many wood-based industries are required and the entire, that empirical study has. to
Oh,
be
we
done.
followed it up.
Yes, Malaj, that is why the High Court was also of the view that.
My lord, my only request is that let them come with the counter, Your Honor. Respondent number 2 and 3 has not yet filed their counter.
There is no need for counter. If there are in fact rules and regulations controlling establishment and monitoring of sawmills.
Yes.
Your Honor, that has not been followed. That is my contention. Your Honor,
If they
that has
don't
not-
follow, it's not a monitoring issue, then there is a violation. You must challenge that violation.
There is a clear-cut violation, Your Honor.
must show
Your Honor, during the pendency of the petition, they have distributed 3,200 fresh licenses, Your Honor. Bihar is not having any forest, Your Honor. They are importing it from other states and they are distributing the license. And Union of India, the Ministry of Environment has totally been ignored, Your Honor. That is my contention, Your Honor. On the last date, Your Honor, my learned friend for 2 and 3 has submitted that they need 2 weeks time to file their counter, Your Honor. Let the counter come, Your Honor. Then after you decide, Your Honor, whatever you want to decide. They have to follow the guidelines given by this honorable court, Your Honor, in many of the cases, Your Honor. My only contention is they should honestly
Okay, let this matter be placed before the Honorable Chief to be listed before the forest bench. No, as a question, the issue involved relates to the allegation of unrestricted grant of forest sawmill licenses in the state of Bihar. Stop. The issue has a direct bearing on the increase in the number of sawmills, without any regulation. Stop. This issue has been considered in Godavarman Thirumal part so and so, and there are certain guidelines about permissions to be granted to sawmills. So in this view of the matter, it would be appropriate to place the, we are of the view that it would be appropriate to place this matter before the forest bench. The registry is directed to place the papers before the Honorable Chief Justice for necessary directions. Take.
Seven.
You unmute him, please.
Oblige, Your Honor.
We have sent it to the forest bench. Archana, let it go there because we are not very sure about. Thank you.
Mate, please. Lord, mate, please, no. But this is that matter which is covered by Amita Hada, my lord.
Comparing to the state, we otherwise have no role, but I was told that Melith had indicated that the state may come because the complainant is not appearing.
Complainant is not appearing, my lord.
We can also, I leave it to the court, otherwise we can also try serving them through the SHO Meliths.
Stage is the case.
Lord,
is there a stay here by you?
Yes, Lord. There is a stay.
We granted.
The state operating.
They never appeared before the High Court also.
It's an admitted fact. Leave granted. We are ready to squash the criminal proceeding.
Lord, if they come here, my lord, the only
Hada is a little doubtful.
But Hada has been followed, my lord, in 4 other judgments in 25 as well. We just give a compilation.
Okay, that's the law as it stands.
Lord, can I just hand over the
leave granted? Leave granted. The short issue arising for consideration is whether proceedings under section 138 of the NIA Act can proceed without the company being made a party, company being arrayed as an accused in the complaint. Full stop. This issue is no more res integra in view of the decision of this court in Anita Hada versus so and so, so and so. Mr. Devdutt Kamath, assisted by Mr. Pulkit Tare, submit that Anita Hada has been followed in a large number of decisions of this court.
I will hand over.
Swati Gidyal, learned counsel appearing on behalf of the state, appears on behalf of the state, full stop. None appears on behalf of the complainant, respondent number so and so, despite completion of service, correct?
Yes, Mr.
Complete. In view of the above, we allow the appeal, set aside the judgment and order passed by the High Court and quash the criminal proceedings. So, needless to say, shall we begin without pain? To implead, limitation to hold here. Limitation.
Yes, Melith.
If he wants to implead the company and then file, it's barred by limitation now.
Melith, I also have my, but that's the law as on today, Melith.
Leave it at that. Sure. We have allowed this petition. Next.
May I please, Your Honor?
Actually, when I argued it, I thought.
Your Lordship, Mr. Naure is appearing in the matter. I'm seeking a passover. I'm seeking a passover. Mr. Naure is appearing for the municipal council.
This is the matter, my lords, regarding appointment of the arbitration clause. Yes, ma'am.
One query.
Right.
Apart from everything else, like your argument that clause amounts to an arbitration clause, that apart.
Acquiescence,
but
waiver. And
No, that apart. But the fact is that you participated in a tender.
True, man.
Right, knowing fully well the terms and conditions, and you were declared the successful bidder.
True, man.
So after acceptance of the bid, can you turn around and challenge a condition in the tender that minimum whatever reserve price should be this X, Y, or?
No, my lords, the distinction is this. We never sought to say that the condition was bad. We only say that the calculation was totally wrong. That is why it went for arbitration. What we say is that we have never challenged the clause as such. The clause remains. The question is what would be the minimum price. The question is there is a formula which is given under the agreement as to what constitutes a minimum price. So on that basis, I was selected. But thereafter, my lords, it found that the minimum price which was arrived at was against the formula prescribed in the contract. That's why the award clearly says that the formula was not worked out properly. So it was not a challenge to the clause as such.
We'll have the other side.
Arbitration. That's why we have. Passover or what do we do?
Well, then have it on,
Large
in
number of
case
matters.
Passover means, then kindly have it on Tuesday and next Tuesday. In case if it is
Today is Tuesday.
in case this
Might have forgotten.
yeah, next, in case there's a Passover.
But your clause doesn't seem like an arbitration clause at all.
Well, it's ultimately,
Except you have a good point on estoppel.
and they, in fact, my lords, both of them agreed before the High Court also. And my lords, normally when we give a solemn declaration before the High Court, we don't
post on so and so. Which date they did not quite Tuesday. Tell Mr. Navre we'll give another date.
Well,
obliged.
Obliged.
My lords, I beg to appear for. Your Lordships had directed, my lords, MOEF and Tribal Affairs Ministries to hold a consultation and file an affidavit, my lords. We filed an affidavit yesterday, my lords. My colleagues are carrying copies. It may not be on your Lordships' record. It's a short point if your Lordships.
What did you say?
So, my lords, what we have said essentially is three things, my lords. First, my lords, at page 2, para 6 onwards, 6, 7, 8, 9, we have given the data, my lords. Data that is specific qua state of Madhya Pradesh and data qua the entire country also, my lords. We have also placed an annexure on record.
Can we have
Second, my lords, our stand qua the intersection between the FRA Act and the Forest Conservation Act is at para 14, my lords. Page 4, where we have said, my lords, in para 14.
We will just recalculate about our order.
My lords, your Lordship's order is dated 23rd September 25.
Something, yeah, they claim order.
Yes.
My lords, we have quoted the relevant portion in para 5.
Can somebody read it?
Yes, your Lordship. We direct the MOEF and Ministry of Tribal Affairs, para 5 of this affidavit we have quoted.
Context, just a little bit more.
My lords, your lordships will remember that these are cases, my lords. The petitioners are claiming that they have rights under the FRA and their houses have been made under the Prime Minister's Awas Yojana, my lords. And there is a private respondent who is a Maharaj, my lords, who also, as per the record that has been given to us by Madhya Pradesh, also has FRA rights in the forest. So it is really
Community rights.
Yeah.
community rights and then followed by individual rights also. So, my lords, that was the issue, and your lordships wanted us to have a consultation between the two ministries.
To build a pakka house for the forest owner, the real question is whether such a measure can be, notwithstanding the regulatory mandate to the forest conservation. The forest conservation, in our opinion, should not be treated as a law which prohibits such an activities, but it is a legislative measure that introduces value. Okay, now let us read your affidavit.
My lords may like to have para 14 once, my lords.
Yeah.
At page 4, my lords.
Yeah.
It is pertinent to note that once individual forest right has been duly recognized by the state government in accordance with procedure prescribed under the Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Acts 2006, the requirement of obtaining approval of the central government under Section 2 of the Forest Conservation Act shall not arise. So we have set out the two sections, Malats, but it is our Malats, it is our view, Malats, that because FRA recognizes pre-existing rights as forest dwellers, therefore those rights, once they are properly established under the regime of FRA, then no prior approval under Forest Conservation Act is necessary.
You'll have to develop perhaps an alternative regime. It is not either that it applies or it doesn't apply. You understand the reasons given by us in our order is
Yes.
to say there must be some kind of a monitoring. You will realize at a later point of time that once you have said that FRA applies and you grant permission or you leave it to those persons, forest dwellers, to live there, after some time you will not be left with any kind of a measure to monitor and then see. If it were under Section 2, some kind of a measure will always be there with the central government to regulate and control. We will then have to see the FRA and see how it could be strengthened then. Let us see further.
Malats, your lordship's
You have referred
concern.
to the 3 under the FRA. Okay, all
Yes,
right.
Malats.
After having said 3, then Section 4, recognition or vesting of the forest rights notwithstanding content over the time subject to the provision of central government whoever recognizes and vested. We
Yes,
are
Malats.
looking at regulatory powers.
I see that, my lords. In fact, if your lordships will see the chart that we have annexed, my lords, your lordships will see a large number of rights have been recognized, my lords.
You are referring to the right. We are talking about the regulation.
I see that, my lords.
We examine how else do you protect the forest then?
My lords,
By
the
far
affidavit
no-
is silent on that aspect, my lords, and I did put this to the officers because your lordships had expressed this orally. So, my lords, I think we'll have to come back on what are the safeguards that should be, my lords.
Limited to an examination of actions. See, we have fought for the right of FRA,
Yes,
but
my
then you should also fight for the.
I see that, Malats. Lordship may record my statement and Lordship may permit me some time, Malats. Because if your Lordships will see page 8, this is the All India data, page 9. This is the All India data, Malats. 51 lakh claims have been filed,
Exactly.
which 25 lakh titles have already been distributed. So this data, your Lordships will see, we put the entire
Exactly
chart,
what we are
Malats.
saying. That
Yes,
is
Malats.
exactly what we are saying.
Yes, Malats.
Imagine all these entering and controlling the forests.
Yes, Malats.
What is the measure that you have to regulate it? What is permissible? What is not? Who does it? Which is the authority?
Malats, it will have to be the state is the competent authority under FRA, Malats.
FRA, does it have a regulatory regime?
Yes, Malats.
Forest Rights Act, there.
Yes, Malats may have this.
Let's the chapter 2 of the FRA, forest rights.
Then, Malats, chapter 3 has duties of
Recognition.
And then chapter 5 has offenses.
Duties of holders of the forest rights.
This is the entire procedure.
This is
Gram Sabha
education.
shall be authority to initiate the process for determining the nature and extent.
I don't know whether your officers are right in saying that section 2 has no application.
So as per section 4, subclause 7 of FRA.
Yeah.
Housing is not there, madam.
Your Lord,
At the
this is 7.
very the unit. Madam, earlier there were only 25. Now it's 63. And madam, that number is increasing, madam, day by day.
Non-forest act.
Please, madam, that's the problem.
Your Lordships may
Whenever it has been decided to constitute the land reserve forest, state government shall issue a notification.
You couldn't live in the forest.
Which one are you saying? Which section? Forest Rights Act, no?
Yeah, 4-7, Your Lordships.
FRA.
Section 4-7 of FRA says.
FRA, no? Yeah, FRA nahi hai, ye Forest Act hai. Anyway, you take instructions on this.
Yes, my lord.
May I just say one thing as a suggestion? What happened actually in this case was that the affidavit filed by the state of Madhya Pradesh says there has been no cutting, no clearing of the forest because it was an already existing kacha jopdi which has become made pakka. But I understand what your lordship's worry is that
We are not concerned about your facts of your case.
Yes,
Your
I
larger
understand.
question.
I understand that, your lordships, if they want time to come back because they've not answered that question.
Doesn't matter.
Yeah.
We are not against you.
I know, I understand that, your lordship. That also your lordships has indicated, but only thing is, your lordships knows we are neither here nor there with half structures now. That has been our plight for the last, because we just 4 people.
We'll find out.
Already got IFR rights, your
The
lordship.
forest dweller doesn't need anything. A
That
tree
your
is enough.
lordship has indicated also.
A tree is enough.
Yes, your lordships.
If you are wanting.
They had a kacha jopdi, your lordships. Now, in view of that kacha jopdi is also not there. Today, even that is not there today.
So this fact that they have got this land in revenue.
You
Therefore,
know,
there is no
this is-
question of settlement.
You know, he.
Don't take it further. Don't take it further.
No, but-
Yeah. Don't address on individual facts. Next.
Your lordships may give them.
You've given them time.
Yeah, but some short time. They've taken 4 months for this exercise.
Now do it faster.
Yes, my lord.
Just tell us. Man, this is not a disposal case. It's a monitoring case. So
Please, my lord.
have it after 3 weeks.
3
I'm
weeks.
ready, my
I'm
lord.
obliged. Item 10.
Dr. Singh, we requested, my lord.
This matter.
This is the matter. So, my lords, he'll come back.
It is like Dr. Singhi will take 100 adjournments in this.
No, no.
I think
No,
97
he's
have
not
over.
taking adjournment, my lords. He's not taking adjournment. Today, there's no adjournment. It's the reason, my lord, he mentioned in the morning. No, my lords.
Manoj, may kindly pass over. Just see.
Okay, he wanted a Passover.
That's right.
Not possible a Passover today. Next Tuesday. Next Tuesday.
Item 11.
My lords, item 11, my lords, one of the impugned orders has been passed by Justice Aradhe.
Oh.
Matter
Impugned order?
has been passed by Justice Aradhe.
Okay. Sorry, we didn't realize.
26, I don't have.
Oh, okay. 12.
My lords, it's a land acquisition matter, my lords, wherein 3 sale deeds was referred by.
You are correct, exactly. You are a subsequent purchaser. What right you have?
My lords,
how are you maintaining this petition?
No, my lords.
And after the 4-1 is issued,
My lords.
all transfers are impermissible.
No, my lords, that.
We are item 12, right?
No. No.
You purchased the property when?
No, my lords, that is not. I'm not think so. I'm the landowner. Where it, my lords, I'm reading from. I am a subsequent.
Which item?
Item 12.
12.
वो 12 में नहीं है. Welcome.
I'm sorry, my lord.
Subsequent
we are-
benches
we are
are वो
at
दूसरा
11.
वाला है.
हाँ. We were at 11.
This is Siddhamma matter. 612.
But 83%, somebody was appearing here.
The
Who is appearing here?
last time
73% deduction.
deduction, that deduction matter. You are right.
83%.
Yes.
83?
83.
83 or 73?
73.
Deduction is not 73, my lords. It's total deduction done with my lords. Some around 83% deduction was.
That's what I'm saying. 83%.
And railway line only, my lords. Recent order is there. If
Who's appearing? Who's appearing? Bring them.
Last time they are here. I want to pass on. I'm apologetic, my lords. That marked by mistake. I'm really apologetic. I ask for an.
No, but what do we do?
There's a railway line only.
Which state is this?
Karnataka.
State of Karnataka?
Yes, my lords. It's a central union is appearing. My lord. Last time the senior counsel was.
Why railways is it?
A railway. My lord.
So then you serve it on somebody who is appeared last time. What is this? What is this order?
This order, my lords, it's also for the railway line only, my lords. And it is their near place of that my land also, my lords. And my lords, here my lords have said that the deduction for how much deduction has to be done, because railways, they are not developing anything. The para 6, if I read, my lords, for my lord's consideration.
So how much? 20%?
20% as my lords have said.
20%.
80 se nikal do 20. Sirf 20.
Judgment you are relying upon, sir.
I'm sure. That Raichur area only. 83.
83. Reduce it to 20.
Then 20 पे ये हुआ नहीं already think दिया था.
Yeah, this is after taking 70%.
No, it's not 80.
77 deduction. What do you say about this? 77% did.
Let me just see, my lords, how it is help, my learner friend, my lord. Let me just examine this judgment, my lords, whether what are the factors, my lords, be taken into consideration, my lords. Otherwise, my lords, kindly see my counter affidavit, my lords, para 2. That's a law point, my lord. Let me just examine this judgment, my lord. Have it. Para 5, lordship is saying. Upon notice, the railways have chosen not to contest these proceedings. It is contended on behalf of the appellant that since the purpose of acquisition is for lying railway line between Mehboob Nagar to Muridabad, there was hardly any necessity of 77% deduction toward development charges, as the entire acquired land can be utilized for the purpose of laying and maintaining the railway line on both sides. It is pointed out that the reference court, after due consideration of the evidence, has found that 20% reduction toward development charges would be sufficient. We find from the imping judgment that the High Court, after taking notice of the acquisition of a large chunk of undeveloped land, viewed that 77% reduction toward development charges from the market value of the land would be justified. We see no rationale or logic behind this in the absence of any categorical finding that substantial part of the acquired land cannot be utilized for the purpose of its acquisition. It is not case where the acquired land would be utilized for the construction of the amenities of the ancillary services. In the very nature of the things, the laying of a railway line does not acquire the degree of development as may be necessary in the case of the development of a residential, commercial or industrial area, or for that matter, regularized urbanization of the acquired land. That being so, the reference court has rightly in applying the cut of 20% toward development charges. Now, my lords, in this case, my lord, the relevant factor, which is the point of distinction, if lordship may see in between, it is, if my lord, we see no rational or logic behind this in the absence of any categorical finding that the substantial part of the acquired land cannot be utilized for the purpose of its acquisition, one. And second, it is not a case where the acquired land would be utilized for the construction of amenity and ancillary services. So, my lord, if that being the case, then, my lords, I can justify that 77% is the right. Now, let me see my counter affidavit, my lords.
Land that was acquired was 2 acres.
It's a completely dry land.
His land was 5.5 acres. Yes. So we will not give 20. We will give more deductions and balance it. Okay. Leave granted. The land acquisition proceedings commenced with the issuance of Section 4.1 notification on 12/2/2004. An award was passed granting no, 41,2000 for acquisition of an extent of 5 acres,
6,000 to 6 lakhs.
2 guntas of land situated in Katlapur village in Raichur Taluk of Karnataka. Okay. While the land acquisition officer granted 36,000 per acre, the section 18 reference court granted 6,36,000 per acre, which came to be upheld by the order impugned before us by the High Court. Full stop. The reference court took note of sale deeds of sale deeds dated 9/10/23, 21/1/24, and 5/1/24, all relating to small extents of land
And develop area.
extending to
Within the city.
53 square yards
Within the
each.
city.
Approximately 53 square yards each. Full stop. The counsel for the appellant has brought to our notice order passed by this court on 9/9/2024 in with respect to lands. We don't know. This is the 4-1 of which
This is
area?
Gadag, this is Raichuru Gadwal railway. Mine one is, this is Vikarabad, the same area.
Also this is in which area?
This is Mahbub Nagar, Munirabad, just above the Raichur district. Mahbub Nagar.
Also relating to Raichur district.
Same line it will come. Mahbub Nagar, Raichur all adjacent to it. That is Mahbub Nagar comes in the Andhra Pradesh, my lords, and this Raichur comes.
Oh, this is the Mahbub Nagar, Andhra Pradesh.
Andhra Pradesh is Karnataka, Raichur, my lords. Same above and down.
Mahbub Nagar, Andhra Pradesh means there's a world of difference between that and this.
Now is Telangana.
Telangana.
Telangana, first Raichur and next Mahbub Nagar.
Just say that, doesn't really matter. Don't say similar.
My lords of
This relevant portion is Assam.
The railway lane is the same.
Para 2 se para 7 quote kar lena. Okay. Having considered the matter in detail, we are of opinion that deduction of 83% towards development charges is on the higher side. Full stop. At the same time, the extent of land involved in the above referred decision is only 2 acres, while the land acquired under the present proceedings, involved in the present proceedings, relate to 5 acres, 2 guntas. Having considered the matter in detail, we are of the opinion that it would be appropriate to reduce the deductions towards development charges from 83% to 40%. Yeah?
35.
40 to 40%. Full stop. This is the only modification of the order. This will be the only modification of the order impugned before us. In view of the law, appeal is allowed. Judgment and order is modified to the extent as indicated here.
Please, Your Lordship. My Lord, this is the matter, my Lord, wherein I was directed, my Lord, to give all the benefit with this, whatever has been given to Mr. C.L. Ohri, my Lord.
Who is appearing?
So for last 2 days, we are seeking time, my Lord.
Dispose of your contempt is disposed of, is it?
Please,
as compliant.
Please.
Why are you wanting all reliefs coming to you through contempt? You don't challenge the
My Lord, there
actual
was
orders.
specific or contempt was earlier challenged in the earlier round of litigation, my Lord, at page 192.
Pass over, yeah. Or next Tuesday. Next.
Deeply.
In item 14, Lordship, I am seeking passover.
Or a Chaukidar wants fixation of fund. Both courts have gone against you. Fixation of scale, is it? What remains in this? What is there? It's not an employment, some refixation of the scales. Why should we interfere in this?
Lordship, I am just seeking passover.
The gift of his this thing, regularization.
Not a case.
Period prior.
You've got substantial relief all through. Leave it at that. Dismissed. Next. Yes. Inca feeders.
Please, Your Lordship.
क्या कर रहे हो?
No, my lords.
Tell him, giving them some relief or not?
My lords, we have if your lordship see the affidavit, my lords, which has been filed pursuant to your lordship's order.
They say that you issued a GO which you can't change
Yes, no, my lord.
the
Now it has
method
been
by
done.
which recruitment is to be
My
done
lords,
by
it
virtue
has
of
been
a
done.
rule
It
can't
has
be
been-
changed by a GO.
I agree with you. I
That's it,
agree.
matter ends there.
I agree. No, my lord. Now it has been done.
Now you can't.
After
do
your
it.
lordship,
Then you exercise that power now.
after your lordship stayed the order, after your lordships passed the order of stay in the SLP, my lords, thereafter, my lords,
You amended the rule.
we took the step. Everything has been done. They can participate in the.
You can't amend the rule retrospectively because you won't have the power to give subordinate legislation retrospectively unless the statute empowers.
Now, my lords, that has been done. These
Okay, we will leave it to you. We will say that.
My lords,
Kawasa.
one respectful submission. After then I will leave it to you.
Mm-hmm.
My lords, as of now, these posts do not stand now there.
You take such action as you want. You will not say anything.
Yes.
Mr. Kawasa, learned counsel appearing on behalf of the state of Jammu and Kashmir, state of Jammu, and state of Kashmir, right?
JNK.
JNK. So both you are appearing. Okay.
Rather UT of JNK.
UT of JNK. It can be both UT of JNK. Rules have subsequently been amended.
This will help me. This
Have
will
subsequently been amended. The government has amended. The government has amended the rule.
both don't. Both. Yes.
Amended the rule by issuing GO number 50 जो भी है dated 31/2024. Full stop. In this view of the matter, the government will be entitled to take such measures as may be permissible under the new dispensation. Okay. With this clarification, specially petition stands dismissed.
Let's, in case they have to. In case.
Whatever, you initiate action, there is nothing we can do.
Very well. As grateful man.
Yes.
Item 16, my lord, my learned friend starts. I
No, we will admit this matter and hear it.
I have preliminary submission, my lord, if you lordship would. The petitioners here in my lordship, they are the one. If your lordship would just permit me a second only, my lord. My submission is, my lord, that there are two petitioners. They did not even challenge the single judge order. They were performer respondents before High Court, so therefore they had no locus to file special petition because they did not question that single judge order, number one. Number two, my lordship, the order has already been implemented, states has already.
Who is appearing for the state?
I appear for the state, my lords.
Already
It has been implemented, the order's been, my lords, everybody as per the order of the single judge, as per as, after the dismissal of the LPA, my lords, we have implemented everybody, my lords, as per
But their
the.
counter says subject to the outcome of the present.
That is there, my lords, because they are here, contempts are being filed against us. What can the state do in this?
Subject to the outcome of the SLP, in fact.
If
After it is implemented, what more?
My lords, may kindly see, my lords, what had happened, that notice on interim stay was issued. Despite that, they implemented, and now in the counter says, my lord, they say that we've implemented subject to the outcome, subject to the outcome of the present SLP, because they have chosen not to challenge the order of the High Court. That is why they have implemented. Your lordship, may kindly see the counter for a moment.
Why
They have
the
implemented.
interference? Concurrently, both the courts have held.
My lords, may
Rule 11.
My lord, here.
Rule 11 note, my lords, basically on the note.
The
Mandamus
way
has been issued
local
against the rules. Mandamus has been issued against the rules. There was a promotion criteria. There was a promotion criteria that has been ignored. Promote under the promotion criteria.
Leave the question of law open.
My lords, may kindly appreciate only one.
It's not a case for.
My lords, may kindly appreciate only one thing. Under the promotion criteria, the stenotypists and stenographers are not eligible to be promoted at all. They can be
Right, Mr.
promoted.
Jain.
My lords,
Not every case we will see. Dismiss. Next, 17.
Your lordship wanted to leave the question of
Question
law.
of law is kept to. After having heard Jain. Challenge question of law.
Please, my lords.
My lords, in item 17, this is that Bihar demonstrators case, my lords. We are being led by Mr. Shankar Narayan.
Why 32 petition, Baba?
Please, Baba.
Why 32 petition?
My lords,
Every time we raise this question, every time.
my lords, we had already responded to that, but just to bring on record, my lords, in our initial submissions which we had filed, we had placed on record, my lords, that 2002 there was a judgment of Radha K. Jha given by my lords.
But we'll keep all the questions, Purushottam, for you to take it up there because we are so much burdened. When if we had that liberty and freedom to, take up matters, it's possible. Just you see how Tuesdays are.
My lords,
We keep take up to 32
bow down.
petitions in a service matters.
Please.
Where will this court be able to handle this?
Not well disposing some
And in fact, we've been putting that caution to you every time it is being.
My lords has always been
of the fact that
my lords, I would be
petition
grateful
under,
with
we
my
are not
lords' permission.
inclined to interfere only for the reason that this is a petition under Article 32 of the Constitution.
My lords, may just bear in mind.
Yes, yes, yes.
My lords, here is a case where there are 96 of us, my lords. We have already crossed the age
All
of
these come
70.
under which will
My lords, 2002, we were parties to my lords.
What we will do is
2017, we were parties to my lords.
we'll protect you.
Contempt, my lords
protect
gave
you
us
to that.
liberty to file an alternative relief. So, my lords,
Alternative
the
doesn't mean
sequence,
32.
if in case I can bring it to my lords.
Tell us
notice.
which court, which is the High Court you are concerned with.
My lords, this is the Patna High Court, my lord.
Okay, we'll say that. We are not inclined to interfere.
parties.
We are not inclined to interfere with the order only for the reason that this.
My lords,
petition
then
under
let me at
Article
least have
32
the
of
limited,
Constitution.
liberty, my lords, to at least have the senior on record, my lords.
We'll note his name.
I'll be grateful.
Don't worry, don't worry. Under 32 of the Constitution of India. However, we permit the petitioner to approach the High Court. Full stop. In view of the fact that this writ has been pending before this court for quite some time, we request the High Court to take up the writ petition upon filing, or shall we transfer it straight away to the High Court?
My lords, I think, my lords, that will be grateful, my lords. And a particular time limit may be
In view of the fact that
we are above
the
70.
writ petition. Yes, we remember.
University can only verify whether they were working, not working when they were appointed.
My lords, we are
Party. Therefore, those universities need to be made part by the High Court.
My lords, to that extent, my lords, we are aggrieved by the state governments to orders, my lords, wherein my lords,
Don't address us
despite
on
my
merit.
lords coming to our aid and saying that your status, rank and payment will not be disturbed, they have still continued and given these orders. My lords, we challenged it in contempt. My lord said that maybe contempt may not be a right remedy and you may explore an alternative remedy. We
we'll
filed
just
the
complete
writ.
the order.
My lords, here
In view of the fact
university
that
has no role to play. We are only agreed with vis-a-vis that.
For quite
I leave it to
some
my
time, we
lords.
deem it appropriate to transfer. How can it be? It can't be a transfer. How do we do?
No, university can
Transfer the writ petition.
My lords can do it.
Transfer, we have done that.
Very many matters.
Transfer the writ petition to the High Court for being renumbered as a writ petition under Article 226 of the Constitution. The registry shall transmit the entirety record of the records of this case to the High Court expeditiously. Full stop. Then you say that we would also request the High Court to take up the writ petition and dispose it off as expeditiously as possible. Keeping in mind, many of the petitioners are senior citizens and have in fact crossed
70
senior
years.
citizens.
Majority of
At
them are
the
above
same
70.
time, we also record the submission of Mr. Ranjit Kumar, Learned Senior Counsel. What objection is that?
That the university who can only verify their credentials, because this is the third round they are here.
But this is
We'll
not
just
on
keep it open.
verification. This is on
We'll just keep
policy.
it
my
open.
lord.
We also, we have not, while we have not expressed any opinion on the merits of the matter, the respondents will be entitled to raise all such objections as may be permissible in law.
Great.
It is for the High Court to take up and dispose of the writ petition on its own merits.
My lords, a couple of months may be given, 6, 9, whatever, my lords. Instead of expeditiously, would my lords be inclined? I will leave it to my lords.
Preferably within a period.
Because my lords, this is a 2024 matter to
4 months.
grateful, my lords. I'm very, very sorry, my lords.
We are also sorry to you, but kept this matter pending, but it's not possible. Just see the number of colleagues waiting for matters. Sir.
My lords, I
We
leave
can't
it
be
to my
taking
lords.
up service matters like this. Thank you.
Grateful, my lords.
Thank you,
Apply.
Purushottam.
Grateful, my lords. Grateful.
Lord 18, there are three set of cases. Can I just give your lordship a small, because there is IE filed. There are
I think there's some
10,000.
solution out of this, no? You have reserved some 100 posts or something.
Yes. So I have a suggestion, Lord, this petition.
What is the
disposed
suggestion?
of.
Yes.
So there are, Lord, 10,700 vacancies. As per the,
Take a quick solution.
as per the 10,700.
All are agreeable about this.
I can just, I think they will all agree.
If we get a job, we are agreeable.
Let me indicate that probably they will.
And the jobs are now very scarce because the appointments have been made.
There are.
Tell us how to resolve this.
10,709 vacancies are there.
10,709, correct?
As per the list, Lord, of the state so far, 8182 have qualified. 8182.
8182.
But
8182 qualified then?
8182. So now remaining vacancies are 2,600, 2,500 and something.
Vacancies.
There are Lord, 800, 100 were there, and there are 700 who have come in Lord intervention.
What we
These
need
people can be considered for the if they have qualified under the unamended rule, Lord. If they also
qualified persons have taken up the job and Patwalia's clients are working?
No, so I am not. There is a small.
Patwalia, your clients are working?
My lord, no, my lord. What has happened is, Lord, let Mr. Singh clarify, I'm not the qualification under the 18 rules or 23 rules.
I'm explaining that. I'm explaining.
Yes, that is
I'm explaining that. I'm explaining that. So your lordships have already, as an interim measure, permitted us to join. There are 600 people who have.
You are the ones who took the examination.
23.
Yes.
There are 23 ones.
I am saying, my lord, that the other people for whom your lordships have kept 100 vacancies, now 700 more people have come. There are about 2,500 vacancies still remaining. They can be looked at by the state by the unamended rule. If they make it by the unamended rule,
that we will ask. Mr. Diwan, you are also appearing.
Yes, in my case, I have the advantage of the 14th May order of your lordships.
They have been appointed.
We've been appointed. So
My lord, we have objections to that appointment.
Who is for the state? Where is this? We are looking for you, Manish.
If it is acceptable to the state,
we'll just see.
My lord, the 14th May order is misconstrued.
Permit us to just listen to what the state says.
My lord, my submission is the figure that has been given regarding the remaining vacancies. It's may not be possible to fill up on these posts of all these candidates because only 100 seats have been kept for all these writ petitioners and applicants. The vacancy which is reflecting, these are the vacancies of different category, like OBC, SC, ST, the candidates have not been found. The handicapped people candidate have not been found. So all these vacancies, because if your lordship see this chart, all the general posts have been filled up.
No, that's also not correct.
Wait. We are not taking anything for granted. Just wait.
All the general posts that has been filled up, only 100 posts have been kept vacant as per the direction of your lordships. Now the vacancy that has been reflecting is only with respect to the other category for which the suitable candidates were not found.
So what's this? What's
the
stand of the state now?
For the 100 vacancy, I have no problem in considering all these writ petitioners and the applicants.
How are there more than 100 here?
Yes. Because writ petitioners,
have been found here for the first time.
writ petitioners were all together 74, 75, and therefore I made in a statement that 100 posts I will keep vacant. Now there are
Then perhaps increase because your total number of vacancies are 2,600.
If your lordship pass an order that no further intervention application is filed, then I will calculate all the eligible.
How many are here?
I have not.
About 749.
Can you just do some exercises?
749. Your lordship may
Freeze it today that no further application.
Today, then on that position, let them do the. And to clarify, my lord, that it shows the vacancies are concerned, it will be the general too, because it's not necessary.
Permit us to just interact with the state for some time.
Very well.
So if we, as you suggest, we freeze the no further interventions, no further, we would say that, and you will take into account in all these petitions the number of petitioners are there, and how and in which manner you could accommodate them. Just have a look at it and tell us.
Yes,
and
that I will do.
In
about 2 weeks, you will be able to tell us 2-3 weeks.
Yes, my lord. Only I will request the nodal counsel for the petitioner and respondent to give me the list of all the candidates who are here.
One small thing, Lord, he should consider. Out of 81, Lord, 86, 82, they have appointed only 7586. We are in this 600 who are, Lord, remaining. If your lordship will just see the last and the second last column.
8186
Can I have
and
a-
7586
We
have been appointed.
constitute a team of senior counsels and lawyers, including the standing counsel for the state of Bihar, to resolve the issues arising for consideration. वो नाम लिख लेना, Mr. Giri साहब का लेना, Mr. Vikas Singh Patwalia, Mr. and Mr. Diwan is anyway out. He's happily out. And state का ले लेना. And who were the nodal council?
Millard.
Okay.
Millard.
And okay. Advocates, the nodal council ka naam will coordinate with all others and give to the standing council for the state the list of the petitioners who are before this court.
Petitioners and interveners.
Petitioners and interveners who are before this court. The state shall examine the employment position and also consider accommodating these petitioners in the existing vacancies. This is all tentative. You will apply your mind. It is also in the view of the matter, for the purpose of resolving the issues arising for consideration, it is necessary to direct that there shall not be any further applications for intervention. Okay. The relief to be granted will be confined to the petitioners as well as the intervening applicants before this court and no further. Yes, that will not take, sir.
My lord, may I also lordship consider, my lord.
Read petitioner before the High Court. Your lordship can read petitioner before
Include them.
Respondents before this honorable court, my lord.
Also, then who will give you the list of the?
And lord, all the read petitioners before the High Court, they are in SLP here. So parties are, please.
Okay, this will cover everyone.
Respondents
before this honorable court.
These will include writ petitions, these petitioners before the High Court.
Yes.
Also.
My lord, if I lordship consider even the appointment of the 14th, because this is all tentative. Supposing we cannot be accommodated the objection, the appointment of the 14th we kept open, lord, for consideration.
Let me just see. Okay, list this matters after 3 weeks, 2 weeks.
3 weeks.
3 weeks, okay, for further orders.
Great.
Just you work on it, and why we have said is that for coordination, so that all of you can just sit for a minute, sit in the consultation room, all for a cup of coffee, resolve it, help him, and we'll just pass orders on your recommendation.
But may I just clarify one thing, my lord?
That is the problem.
My lord, kindly allow my attitude. We could of course come back on the next occasion, but otherwise your lordship that the appointments made pursuant to the interim order of this court of 14th May, they be made absolute.
No, absolutely not. No, we have got very
not at this stage.
I have not passed.
Very well. All right, that's the reason why I
taken for granted. We'll do that. We will not ask anybody to go home.
My lord, seeking permission to permit my law. Aye, my lord. Aye, my lord.
Look, this
May
actually,
it please your lordships.
this actually
Let's,
would resolve the problem for about 9,000 plus.
My God.
Problem.
That is why, that's why I thought it would be better that this team will sit together.
And for them,
वो लेखी का नाम भी लगा ना, Mr. लेखी का नाम भी है.
For them, it's a job.
It's a life here. Job is a life.
May it please. May it please, your lordships. Let's aim for the petitioner in item 19, my lords. My lords, in a writ petition, an order of the 34 court has been interfered with. Your lordships have frowned upon such practices.
Redeposit, it's a Lombardy judgment.
Yes, Lombardy, and my Lord Justice Narasimha's judgment in that ONGC case, here the High Court says in a writ petition that the clause in the arbitration agreement which requires 75% pre-deposit is violative of section 28 of the Contract Act. that is directly contrary to my lord's judgment in ONGC. In para 12, my lords say that was a case where the arbitration agreement.
Contrary, is it?
High Court says it is contrary. It virtually strikes down the provision. And my lords, in writ jurisdiction, your lordships have any number of times said.
Invocation of somebody from filing a 34, is it?
No, my lords. My lords, the submission is this. Clause 26.3 at page 34 and 35. This clause requiring the party who has an award against him, the judgment debtor, to deposit 75% on a 120% bank guarantee. I have the award in my favor. I have to give him 120% of that amount against which he shall deposit. And on a final adjudication, if I have to return the amount, I will return it with 10% interest. If there is anything remaining, he will give to me with 10% interest. This is an inter partes arrangement. Now, under section 28 of the Contract Act, your lordships have taken the view that once there is a decree, if the parties agree that the judgment debtor shall not appeal with a view to give a quietus to the dispute, that clause preventing an appeal is also good under section 28.
Now, did we say all that? You are putting words in her mouth. Show us that judgment.
I must be, your lordships meant there are any number of judgments in Allahabad full bench.
Sure.
Yes,
Or judgment.
please give the compilation.
Yeah,
Is it number?
Yeah.
Is it number?
Just giving this clause is a little overreach.
That is the extent to which your lordships have said that.
I don't know.
This has the compilation. I'm sorry, my lords, in the hurry, my friends have not been able to paginate it and put an index to that.
Where is this?
My lords, let me tell your lordships. We have Kolkata High Court, Bombay High Court, 1976 Karnataka, then 1929 Audh, and 1926 Sindh. All these judgments take the view.
Pendente-lite interest, okay, that is a different.
Pendente-lite interest, my lords, that is my Lord Justice Narasimha's judgment in ONGC, where your lordship said that it's a matter of contract.
Okay,
It's a matter of contract. Now, my lords.
You have read too much into our order.
No, please see. Please come to para 12. Please come to para 12 of my lord's order. Where is it?
If an agreement stipulates that no interest is payable, the
Para 12.
arbitral cannot award interest for the aforesaid period and award contrary to the terms.
Therefore, if the agreement stipulates, middle of the paragraph, my lords, para 12. May I place that? Therefore, if the agreement stipulates that no interest is payable, the arbitral tribunal cannot award interest for the aforesaid period and an award contrary to the terms of the contract.
1 minute.
Yes, my lords. Yes.
In case of a challenge, in case he wants to challenge the petition, and the High Court has held that this condition is direct.
It doesn't, my lords. May I place this in this perspective? May I place this in this perspective? For a moment, let us.
Remedies must be convenient. They can't be the contrary, inconvenient remedies, inaccessible. We have given that one other judgment, NBCC. We have explained what a concept of a remedy is. Check that judgment.
Yes,
that's it. That is how these are remedies. Because if the award is against you, you have a right to challenge in appeal. But if you put 101 conditions to appeal, you are virtually taking away the remedy.
There are two submissions to it.
And you can't put contract clauses against the remedy.
There are two.
Statutory, right?
Well, it's 34 is statute.
30. You can't restrict 34 by a contract.
In my respectful submission, my lords, 34 is not being impeded.
34 by contract.
34 is not being impeded.
34,
now
you apply 36 for that.
Now, please look at it.
Wrong.
Please look at it like this, my lords. I'll examine NBCC. Your lordships have. I will examine that NBCC judgment also. The other thing is, my lords, please look at it. This 26.3.6.
Such clauses are impermissible.
I will make an endeavor, my lords, to make good the point that.
Okay, you get ready and come.
Very well. Next week, Malats.
Next week.
Very well.
That is NBCC.
I'll have a look at it.
NBCC, and today there is another judgment. Today's judgment also talks about remedies, how arbitral remedies and appeals will apply, and how courts should interpret, constitutional courts when they interpret remedies, how it should interpret it in liberally, not to restrict it.
Very
As it is an arbitration, is restriction is 34 is so limited, and through contract you will make it even limited.
Malats, the submission is 34 is independent of this contractual right.
You can't
If the
override
clause is
it.
so interpreted that I can't enforce
See our
my deposit, I will have
We'll
it.
get the better.
I'll have a look at it. Definitely, Malats. Great. Next week, Malats. Grateful.
Well, it's item 20. I would request for 2 weeks further, Malats. We had a meeting with all the employees. I'll get back with the report.
Give them some employment.
No,
Watch people.
you
need them in your state.
No, I've not got the report what happened, Malats. Keep it after 2 weeks. I'll come back.
After 2 weeks. Next Tuesday.
Please, Your Honor, I'm requesting for a pass-over, Malats. Malats, I'm requesting for a pass-over.
Item?
21.
21.
There is no.
Lordships, I have to begin. Please.
Pass-over.
Grateful.
Who is asking for a pass-over?
Malats, the state is asking for the pass.
State,
Yes.
1 minute.
Municipal Council, number 2. Yes, Lord.
You are locus. You permit us to ask.
And Lordships, may I explain? First, I file a PIL. A comprehensive PIL is filed. Then
what is your interest? And moreover, he has not taken the employment under the SC certification.
Lordships, there is.
State has explained it very well.
A state has not. It's Lonavala municipal. May I just show? May I just show the
Follow
document?
some discipline. When we ask petitioners, only petitioners will answer.
May I just explain what it is?
But what is your personal agenda?
There is no personal agenda, my lords. I had filed a PIL. I was.
In a service matter, what PIL?
Lordships, that law is also settled, which I will show from the judgment.
Nothing. You are not interfering. Dismissed.
Lordships.
Not
Lordships may kindly consider, because
Do
notice
better
was
things.
issued.
PILs are meant for better things, not for
Notice was issued on this count only. I had relied on one judgment, which shows.
This court has taken care of people who have wrongly used SC certificates. There is law on the point also.
May I just show
So
one?
even assuming for a minute that somebody has wrongly used, got into employment,
Yes.
ONGC and other judgments speak about that issue.
The High Court has
They are not going to interfere in this.
High Court has affirmed the findings of their invalidation of caste certificate. May I just
Nothing,
show
we are
that
not
part?
inter- we are
May
not
I just show that part,
State
my
is
lord?
Not necessary. Dismissed. Item 20.
Grateful, my lord.
Please, Manoj. Here, I just narrate the facts in brief, my lord, because High Court, my lord, allowed.
Chairman, what is the story?
The story is the petitioner, Lord, he was
Three, 4, 5, 7, 13, 15. Copy and 20. You're for whom?
as the High Court was Yes, well, it's,
So can you continue like a member of an agricultural produce marketing committee without being a member of a village panchayat? That's the only thing.
but my lords,
You have been,
yes,
the petition, the relief has been denied to you only on this ground that you suppress this fact.
my lord,
That
may
you are
I,
no longer a
may
member
I
of a
just
village panchayat.
mention one thing first? During the course of hearing, this point was raised.
Yes.
There was no chance for the petitioner.
No, you were present in the court. The
Yes.
High Court
No,
has
but-
said that you were asked to explain. The council asked you.
Yes, yes, my counsel was there, but this objection was never raised at anywhere, neither before the district deputy registrar nor before the High Court. High Court at the last moment. So there was no occasion for the petitioner, in a proper way, I would say, to counter this allegation. And my lord, admittedly, the High Court has arrived at a conclusion that there was no hearing at all. While passing the order by the district deputy registrar, no notice was issued.
Let us see, is it an ex parte or a high court judgment? Let's see.
May I read from page 2 of the...
While issuing notice, the following order was passed.
Yes, my lord, yes.
30 courts.
Yes.
Then as no, first of all, look at the cost, look at the appearances. Advocate for petitioner, and that is you. Gawande was appearing.
You're saying district deputy.
Yes, my lord, yes. No, district deputy registrar.
Deputy registrar.
Why the High Court allowed the petition in part to the extent of petitioner number 2 before the High Court? Because admittedly,
Deputy registrar.
district deputy, yes.
What is the date of that order?
30th of January 2025. It is at page
January 25.
111. And just before that, my lord, page 109 may kindly be seen.
But anyway, when he passed that order,
yes,
you challenge it, right?
Yes. No, my lords may consider one fine aspect of this matter. The district deputy registrar, this is out of political rivalry only. The district deputy registrar, my lord, suo moto, directed the assistant registrar to conduct an inquiry. The assistant registrar prepared an inquiry report, which I had challenged before the divisional joint registrar at page 109.
So but today, what's the position? So when the disqualification order is passed in January 25, you filed a writ which got dismissed.
Yeah, but this
Now, in the meanwhile, what happened?
My lords have protected me by interim order.
You are continuing.
Yes, ma'am.
You for the state.
Yes. 4th of March order dated 4th March 2025.
Unilateral decision. Unilateral decision.
Yes, ma'am.
So what's formulate your point and then argue? Don't.
First of all, my lords, I was not heard by the district deputy registrar. One.
Show us that order. First of all,
Yes.
let us take that order.
Yes.
We're
Page
saying people
111. Before that, may I just, my lords,
Under the statute.
please, pardon, my lord?
He is the statutory authority.
Yes, no, district deputy registrar. Yes.
And there is no appeal against that order.
I preferred a writ petition, my lord, which was entertained by the High Court.
Is there an appeal against that order? Section 45 of the Maharashtra Agricultural
Yes.
Produce Development.
I will just verify. Just before that, would my lords kindly turn to page 109. My lord, this is very crucial.
10?
109. I appeared before the district deputy registrar and submitted this application. May I just read, my lord? We respectfully submit that the report dated 7th of January 2025 of the Assistant Registrar Cooperative Societies mentioned at point number 5 of your letter is one-sided and is prepared without verifying the consent documents and original proceeding of Agriculture Produce Market Committee, so and so. The report is wrong and it is our opinion that the same is prepared under some external pressure. We, against the said report, have filed a matter before the Divisional Joint Registrar Cooperative Societies, Amravati. The date of hearing of the said matter is not yet fixed. Hence, it is requested that no action should be initiated till any order is passed in the said hearing. My lord, this application was submitted on 28th of January 2025. And on the basis of the report itself, the divisional joint registrar, the district deputy registrar, my lord, disqualified us. My lord, High Court has dealt with this aspect in a proper manner. My lords may just turn to page 2. Page 2 of the impugned order. My lord, his petition was allowed by the High Court.
Who is petitioner number 2?
Yes.
Who is the petitioner number 2 before the High Court?
Before the High Court, my lord, he was the vice chairman. Against whom? Yes, my lord. So, yes, my lord. So this order, my lord, my suit can also follow his suit. Yes, my lord. Yes, my lord. Yes. Yes, yes. 28 one is the application, 30th of January 2025.
So we'll simply say that
Both as my lords, they don't stand on same footing. Let me explain, my lords. 2 minutes, not more than 2 minutes. Page number 5, my lords, of the impugn order. To be a member of APMC, you need to be a member of the village panchayat. Now, his village panchayat has merged into the municipal corporation. So once it has been merged, so he does not represent any panchayat, my lords. To have a membership of APMC, he needs to be a member of the village panchayat. Now, there is a judgment of the Bombay High Court which says, my lord, it is there in my counter at page 6, my lords, which says, once you cease to be a member of village panchayat, then you can't be a member of the APMC.
we will
Now,
not get into. Okay?
This issue can be taken care of in the remand proceeding. No? You
my
are
lord, he
entitled
continues to hold the office in meanwhile, my lord. That's the difficulty because he does not represent
It is-
anyone.
by virtue of interim order, he is continuing in office.
Okay. Leave granted. Third, learned counsel for the petitioner and the respondent, appellant and the respondent. It is not necessary to delve deep into the facts of the case, except to state that the notice dated 28/1/2025, followed by the order passed by the district deputy registrar dated 31/1/2025, do not draw any cannot draw a distinction between the appellant and the second petitioner before the High Court. Naam le lena. Second petitioner before the High Court.
Is pro forma respond number 14 in this petition.
Second petitioner before the High Court. Naam le lena. Okay. In this view of the matter, we are of the opinion that the High Court committed an error in dismissing the case of the petitioner and at the same time remanding the case of so and so for consideration. Proceedings are restored in the file of the first respondent, is what he said.
District Deputy.
Remanding the case to the
District Deputy.
District Deputy Registrar. At page number 5 quote कर लेना order करके and this show the matter. The appeal is allowed. The judgment and order passed by the High Court is modified to the extent of remanding even the appellant's case to be considered by the first respondent. और कुछ बोले? Paragraph number. The authority shall consider the case of the appellant as well as so and so on its own merits, uninfluenced by any observations made by the High Court. We have also not expressed any opinion on the merits of the matter.
Well, it's only small request. It may be decided within
Yes,
6
yes,
months.
yes, yes.
Within 6 months.
We would, there shall also be a further direction that the decision shall be taken within a period of 6 weeks from today.
Lord, he was playing 6 months, 6 weeks. Lord. Again, he may not make a hurry. Lord. That is my anxiety. 6 months.
6 months?
6 weeks, man.
He wants to continue.
Obliged.
Okay. 2 months from today.
Yes. Obliged.
My lords,
Please observe the
my lords may kindly pass over the matter. Learned is on her legs in another phone.
Which one?
23.
23. Customs inspection. What is this?
They wanted to find a reminder whether.
Okay, next Tuesday. Next.
Lordship is
Much-
keeping it.
Next Tuesday. Next Tuesday.
Much obliged, my lord. Item 24.
Combination.
Your Lordship, it is a batch of 4 SLPs. One reply has been filed in the connected SLP. I'll file the reply in the course of the day today. If your Lordships can fix a date.
Why don't you accommodate him? It was allowed. You're for whom? For the petitioner. Okay. 4 questions. Acha, this question paper. 4 questions. No? It's not a remind. Oh. Yeah. This is the recruitment relating to the 2017 exam.
Lordship,
Are there any?
It was over. It was over in 2018. People have joined and people have been working since 2018.
It's a promotion. Are still there.
Now, what for these 9 questions which were either out of syllabus?
Okay, you also take instructions. You put your rejoinder on thing. We will dispose it of next Tuesday.
Your Lordship, I'll place my counter in the.
No, don't take further. We have already seen it. Next Tuesday, we'll dispose of it.
Your Lordships, I'm only praying that since your Lordships are taking the matter on next Tuesday, I'll file my counter in their case in the course of the
Do
day.
Do that beforehand.
Please, please, your Lordship.
25? 24. अगर आप करें तो डिमांड करेगा तो
Yes. May it please this honorable court, my lord. As permitted on the last occasion, I have filed additional documents from the record. Also, in keeping with current judicial perception that brevity is the soul of wit in oral argument,
I've filed written submissions, my lord. May I place those written submissions? It will cut short the time. Please see the volume. It's filed as, yes, as a separate compilation. Filed on the 18th of January.
Do not have the copies of it. I'm so sorry, my lord. Put it that way.
Look, take into it. We'll take it up on Tuesday.
Great,
Next
my lord.
Tuesday.
Great.
Next Tuesday we'll take it up. You're not adjourning the matter. Give him a copy. He says that he
Yes,
doesn't
we
have-
served copies on them, Lord. So I didn't know that
I do not have it right.
disorganized. I'm sorry to say, like most state council, their offices, because they keep changing also. We
Okay,
served an
come
advance
back on
copy.
Tuesday.
My lord.
Lord, if I may place that.
काउंटर एफिडेविट पैराग्राफ 10 में है काउंटर मैंने देखा Tuesday.
Tuesday, my lord.
In this matter, my lord, the impugned order.
Please, my lord. Lord, in the impugned order, Honorable Justice Alok Aradhye.
Oh, yes, yes.
One of the members.
Yes.
I heard the matter.
26.
Yes, next matter, 27.
Okay.
My lordship, the counsel, arguing counsel for the petitioner is appearing through VC.
All right. What is this case? Recruitment.
Yes.
Or everything is over. Who is appearing? 27?
I for the petition.
Strategy.
27.
Yes, yes.
Yes, but in the year 2018, the advertisement was
Nowhere
published
in the
for
priority.
I have not applied under the priority. When can you come to page 2007 notification, which is at page 24 once. I did not avail the marks also. Page 27. Can you see page 27 once? For the priority, there is a 24. For priority, who are the son of ex-servicemen, 20 marks is allotted in serial number 1, Roman 1. I have not availed this. I availed the benefit of NCC certificate. The notification says that NCC certificate holder will be placed at the top of the merit list. That has never been considered. Now the Honorable High Court, at the time of dismissing the writ petition, was of the view I applied for the priority. Even in the advertisement in 2018, it does not speak about any priority. I came to know about the priority after publication of the merit list in the year 2019, when I filed the RTI application before the authority to get the information why my name is not published in the merit list. Can you come to the RTI information, which is
How can you, what right you have? Because nobody.
Hello, I got 200 out of 200 in the examination. Even then, I out of the consideration zone.
Mr. Counsel, they have the policy to fill up the vacancies as per the priority categories. The stand is that the vacancies have been filled up from priority category 1 to 4. You fall in priority category number 5. So that's a policy decision that in order of priority, the vacancies will be filled up. It's not your case that any candidate less meritorious than you has been selected from your category. So what would be the scope of judicial review in such a case?
But what has happened? I have not availed the 20% marks
No,
for
leave it
for
back.
the
We are
priority
not
category.
interfering in this. All also. Thank you.
And also kindly consider one judgment, my lord. I have annexed in the
Leave
my
it at that.
rejoinder
Thank you, dismissed. 28.
In this, the settlement talks are still ongoing between the parties. If my lords may have it after 4 weeks.
Why don't you come tell us next? Okay, after दो हफ्ता छोड़ के Tuesday लगा देना. Settlement. Is it true? Settlement?
My lords, they're in process. Your lordships had in fact stated that it will be better that the matter is
Yes,
settled instead of a BG order being upheld. So in view of that, the talks are ongoing and we are positive that they may yield a positive result.
All right. 3 हफ्ते के बाद. All right.
Grateful, ma'am.
Grateful.
My lords, I am appearing for the state, my lords.
Refund all through rejected in the electronics.
My lords.
Who is appearing? You're for the revenue.
I have got the respondent, my lords. Learned ability is on his legs, my
All
lords.
right, we are asking for the petitioner.
Lordships, I am appearing on behalf of the petitioner.
Your refund is all through rejected under 2012-3.
Lordships, we were told that the respondents will be taking some time or a passover in the...
Matter, tell us. Non-consumption of goods without consumption or sale. What do you say? Entry tax.
Item 30.
Item
We'll
30.
be heard. Yes.
30, there's a letter.
Lordship, date may be fixed, Lordship. It's a student's matter.
All right.
2 weeks.
31.
There's a very short point.
It's the final disposal. Oh, Astral Director.
I'm praying for a short passover. I'm
I'll
led
just-
by Mr. Gaurav Agarwal. He's on his legs in court 14.
Time bar claim. Time bar claim, no?
Yes, time bar claim, that's the only point. And whether an acknowledgement could be given by a RP, whether that can extend.
What do you want?
But passover for Gaurav Agarwal or any date of your lordship coming.
No, my date will pass.
No, pass it over. No,
Pass it up. 32.
Yeah, we are no problem, but we are a little anxious because there's no interim order. Your lordship said
We'll argue. We have no difficulty in arguing.
Sorry?
Mr. Gaurav Agarwal is.
No problem.
He's before like. 32 lordship. Mr. Novre is at.
My lords, I am.
Novre is right behind you.
My lords, for the respondent, I am seeking passover because I am late.
This is the Infrustructure's matter actually. The
Sorry, my lord.
appellate forum has passed an order. The original writ petition was against the stay proceedings.
Appellate
Point
forum,
out, my lord,
when was
the
the order
State
passed?
Council doesn't want it to be heard because there is no
When was
power
the
of
order
removal.
passed?
He was disqualified as a
When
chairman.
was the order passed?
12/1/2026. That he has only filed in the IA. Challenging it here.
We haven't seen it.
Notice was issued with clear knowledge. My lord, I will point out. An elected member of a, my lord, Agricultural Produce Marketing Committee from the constituency of farmers.
Order.
Was under.
My lords, on behalf of the complainant, my lords.
My lord, I will show 3 provisions and there is no power.
Tell us.
No, but if the appeal itself has been decided.
My lord, your lordship may remember 2 weeks before, my
One
lord,
minute.
your lordships had made an observation. What is happening in Maharashtra? This is one more case. My lord, there is no power to remove. My lord, collector and the director, my lord, the commissioner exercise the power under the election rules for removal of elected members.
So what happens to the appeal part of it? All right.
Yes, my lord, this was shown and therefore your lordships.
What happens to the appeal? Now,
Appeal is dismissed.
It's against.
Although, my lord, by way
you
of.
can't survive on the interim orders. Yeah, your appeal is disposed. No, dismissed.
I-
What have you done about it?
May I just point out, my lord, please, my lord, this is the way, my lord, the state
I
authorities.
understand, Mr. Navdev, we are with you. That's why we granted you stay.
No, there was no stay. Your lordships, my lord, thought that your lordships let the appeal be heard You point out these provisions. Those were pointed out.
So what? So
Please have a look at 3 provisions. I will demonstrate that, my lord.
in which manner are we to give you relief?
Yes, I will point out that.
Tell us.
I will point out that, my lord. What happens is, my lord, somebody files a complaint on the basis of which so-called proceedings are conducted, removal. My lord, section 17 gives power to removal if committee passes a resolution, my lord, by a particular number. So, my lord, this is not what is invoked. Section 45, my lord, allows some similar power in the government for supersession of committee on stated grounds. That is not invoked.
You are addressing merits, Mr. Navi.
Yes, there is a reason for that.
You tell the point and then argue. No?
I will point out.
How are you expecting us to?
Lord, that's what
relief to you is what we are asking.
Therefore, Lord, I wanted to point out, Lord, just 2 weeks before your lordships made a similar observation. Elected member from the agriculturists constituency to the APMC who became chairman, Lord, sought to be removed without a power. Lord, that's what, Lord, he's something extreme, and therefore, Lord, state authority doesn't want, the state doesn't want this to be shown. Please have a look at the provisions. Lord, in Maharashtra, this is a repeated problem which is occurring. Lord, there is a reason. Lord, yes, my lord. My lord, for that.
We'll remind you. Just relax a little bit.
Yes.
Understand. Your disqualification.
No, not
disqualification.
I'm removed. I'm
removed. Okay, against the complaint.
Yes.
You filed an appeal.
Yes.
The appeal, you didn't get an interim order. You went to the High Court. High Court dismissed. That's why you are here. In the meanwhile, appeal is disposed of.
Yes, I will point out.
Therefore, this order which has been passed, final order, appellate authority, is it an appealable order?
No. Against that, the only remedy is, my lord, approaching the High Court by way of writ petition.
Right.
Lord, there is no difficulty about
Then
that.
wait a minute.
Yes.
Your anxiety will not destroy your own case.
Very well, Lord.
You challenge that order. We will protect you. We will protect you in the meanwhile. If you are working, we can protect
I'm not
you.
working.
Someone new election has taken place.
May I just point
That's
out?
the reason why High Court disposed of.
Take a minute. What happens is, when, my lord, I move the appellate authority.
We didn't know last time we didn't grant you that interim order.
No, my lord, that was, but you will also.
Perhaps for the reason that we were not very sure. We were about to grant you an interim order. But we thought we don't know, let them come, we will check up.
Yes.
Did you hold an election in the meanwhile?
No, earlier, prior to that, prior to they going to the High Court.
Chairman is elected, but my lord, that vacancy, my lord,
Impugn order itself, my lord, the High Court disposed of.
Mr. Chaudhary is not making correct statement. I was initially elected as a member.
This is how they are defeating and killing democracy.
Please see 3 provisions. Lord, I want your lordships, my lord, to consider of granting me protection. I will approach the High Court. There is a reason for that. Therefore, would my lord just have a look at 3 provisions?
Consider, Mr. Navi. You want us to grant you, if it were a situation where nobody had been appointed, then are you saying that
that's what I'm saying?
Nobody has been appointed?
No, that's what I'm saying. I was elected as a member of APMC. Within the committee, I was elected as a chairman. Because I was removed as a member, somebody else is elected as a chairman. That doesn't mean that the vacancy, my lord, which is, my lord, created because of my removal, has been filled in. To that extent, my learned feed is not right. Because I was removed as a member, chairmanship goes, and therefore that chairman post, my lord, is filled in by other members of some other member of the committee. And my lord, what happens is, I will point out.
We will say all that will be subject to, all those appointments will be subject to the outcome in your, 2 things we can do. All that will be subject to the outcome of the order passed either by an appellate authority or by the High Court.
No, appellate authority has dismissed the appeal. So, my lord, what remains is
current judgment.
Number 1. Number 2, wherever the forum is, we will ask them to decide in a month's time.
Please, my lord. Your lordship may please do
That's
that.
the best way to protect you. That's the best way to protect you, because in the circumstances, this is circumventing the law. We quite understand. Okay. The petitioner is before this court against the order passed by the High Court on 21/11/2025, dismissing the writ petition filed against non-grant of an interim order pending disposal of the appeal filed by the petitioner. Full stop.
Correct?
The appellate authority has passed final orders on 12/1/2026. The present specially petition has become infructuous. However, in view of the fact that the petitioner is an elected representative, he will be entitled to challenge the appellate authority's order dated 12/1/2026, and his rights have to be decided expeditiously. In this view of the matter, we permit the petitioner to avail such remedies as may be available, including filing of a writ petition before the High Court. High Court, High Court, okay. In High Court, we would also request the High Court to take up and dispose of the writ petition as expeditiously as possible, preferably within a period of 60 days from today. This order is necessary in view of the fact that the petitioner is an elected representative. And that's all. Anything further?
Lordship may mention from the date of filing of the writ petition. That will file within 2 days. And my lord, your lordship said one more thing, that the appointment which has taken place will be subject to final approval.
Okay. Needless to say that action taken pending disposal of the appeal or further judicial appeal or judicial review proceedings will be subject to the outcome of the decision of the High Court.
Please, my lord. I'm so obliged. I'm so obliged.
Item 33.
I'm obliged, my lord.
May I please, Lord?
Your lordship, I'm requesting for an adjournment. Lord.
It's my humble submission, Your Lordship. I'm highly objecting, Your Lordship.
Your
Lords,
lordship, the arguing counsel.
There are several occasions, my lords, if my lords consider, they are seeking adjournment only, Your Lordship, and till date they are enjoying the stay order of my lord.
Your lordship.
Very small issue involve this matter, Your Lordship.
All right. FIR.
Only they are enjoying stay.
Okay, Tuesday next Tuesday. Next Tuesday.
Obliged.
34. Next Tuesday.
Good.
My lord, I am for one of the respondents, my lord, in this appeal, my lord.
I am for the respondents in this.
The last order, we have to prepare a short list of dates.
What is this about?
My lord, this matter is about, my lord, incorrect answers in the TET examination of 2014. So, my lord, the West Bengal TET.
Board is it?
Sorry?
High Court asked the board to give.
I'm sorry?
1 mark each.
6
marks.
Six
Six marks.
marks were to be given.
My lord, we have only one short objection, my lord. The court said that the 6 marks should be given to everybody, even those who haven't attempted those questions. Now, my lord, that appears to be an unfair advantage, because this is not a case, my lord, where there was any negative marking. So if there is no negative marking, then people do not take a conscious decision to leave something out. There is no reason why they should get, my lord, extra mark for not having tried a question. That is the only point.
Petition and lordship, those who have already got.
We'll just pass over and take it. We'll pass it over and take it.
Yes, yes.
There are some more matters which we need
Oh,
to
enter
reach
the-
and pass orders. There are some.
State has chosen one. So about 5,000 people need to be heard.
5,000
This is a-
people need to
this
be heard.
This is a qualifying. My lord, one.
Pass over, pass over.
My lord, then
Come
your
back.
lordship may take it in the next week. I have a matter at 2:30 today. So your lordship may just do it next week.
Yes, yes. Next week is fine. my lord. No difficulty.
You know, Joe, almost when we are saying.
Well, there are several impleaders also.
Yeah, please, Krishna, Sana Chagin. No?
Yes,
Don't
yes.
Put it down the list, please. All that will be taken up tomorrow, next week. Till next week? It can't wait till next week.
Next week, my lord, we'll do it next. Great.
The list of dates
Grateful, my lord.
that time, so that next time there is.
Well,
the list of dates, we'll have a common list of dates from the side of petitioner and one from their side. So it'll be convenient on the next day.
This is a qualifying examination. We are not being appointed. There is no list of dates required.
List of dates is not, my lord.
It's not at all required.
There are only six dates and all are admitted.
Give it to them.
Item 35, Your Lordship, Learned SG is leading me. He's in some difficulty. So I'm only requesting tomorrow or any other day, Your Lordship.
We'll dispose it off. You filed an affidavit. Now what remains? We have already heard
Tomorrow, Your
everybody in detail.
May I
Everybody is
request-
agreeable also.
Their request for tomorrow.
So therefore, we will dispose it off on the basis of your affidavit.
Tomorrow.
Okay, tomorrow.
Very good. March up.
No, just one thing I should flag. One thing we need to flag before your lordship.
Let it come tomorrow. Tomorrow.
Very well. Because there's some misgivings about one aspect of it, which will
Come tomorrow.
place it before your lordship.
Your Lordships, I'm appearing on behalf of the state, Your Lordships. We have a small request. Your Lordships may consider adding.
Lordship may remember this matter. My lord, the state is avoiding this
Your
for
Lordship,
the time.
two submissions, Your Lordship. One,
What is the problem?
Your Lordships may considering NCB, the Narcotics Control Bureau, as a party also, Your
No,
Lordship. So that
not
they
required at all.
Listen, what is their position?
This is all
in
dilatory
regard-
tactics.
Your Lordship, it's not delay tactics, Your Lordship. The Drug Disposal Committee has a.
Vehicle को release करने के
हाँ.
लिए कुछ नहीं है.
My lord, this is something serious.
See, I have some issue.
Only in the state of Tamil Nadu, it states drug disposable committee.
Your
Are you ready?
Your Lordship, Your Lordship
Are you
may
ready?
consider.
Are you ready?
No, Your Lordship. Your Lordships may
What's the
consider.
problem? Why are you not ready?
The senior is arguing, is on his legs in some other court, Your Lordships. Your Lordships may consider keeping this matter on a non-miscellaneous day on a Thursday or as a fixed matter, Your Lordship, at 2 o'clock.
It's a fixed matter. Today is non-miscellaneous day. Today is a very good day, auspicious day. Tell us.
Your Lordships may consider including NCB also, Your Lordship, because Drug Disposal Committee is given certain functions and powers, Your
Here,
Lordship.
we think it's appropriate, we'll do it. But
Yes, Your Lordship.
that's no excuse for not getting ready. Let him start.
Your Lordships may grant me a passover. I'll.
Do one thing.
Yes, Your Lordship.
Get ready. We'll take it up on Tuesday.
Yes, Your Lordship.
Okay, no further.
Your Lordship,
Yes,
on
no
a
further
Monday,
adjournment.
on a Monday or a Wednesday, Your Lordship, not on a Tuesday, Your Lordship.
Don't take things for granted. Okay, Tuesday कर लेना मेरे.
My lord.
We'll take it up on Tuesday.
Yes.
Your concerns, you put it up in the paper.
Yes, my lord, a written submission is filed, a compendium of cases is filed. They have also filed.
He's saying that this has become abuse, harassment. We'll hear both of you. Tuesday.
Next Tuesday, my lord. Yes, sir. Small.
Long dates, because once we have seen it, it's better to dispose it off, no?
Yes, yes.
Or else if you adjourn it by 4 weeks, again it will go off the 10.
No, my lord, I intend to argue.
Tuesday.
Yes, my lord. One indulgence, my lord, little high up on the board.
We are reaching matters. Huh?
Your Lordships may have it.
37.
Like, my lord.
It should be next Tuesday.
Worship, right? Item Worship, in 37, the petition involves challenge against the
32 petition.
30, also SLP is also there. What happened is the petition involves challenge against the prospectus issued by the respondent state for admission of MBBS courses. So I challenged the prospectus before High Court in 2019.
Not applying now. Wait a minute.
No, Lord.
Will we open the file?
I am requesting for a week accommodation, Lordship. That's what I am saying.
Why, sir?
Because, Lordship, this prospectus, initially I challenged it before the High Court of Kerala, and the judgment was delivered against me. That was under challenge before your Lordship in the SLP 37.1. In subsequent years, the state issued the prospectus with the same clauses. I filed the writ petition directly before this Honorable Court, and your Lordship was pleased to issue notice in those writ petition tagged with this SLP. Now, this academic year, they have already issued a prospectus. I challenged that also in the writ petition, first writ petition. That is only there is, that is some defect. I will clear the defect and get it this along with that.
I don't have any objection, but.
I will get the writ petition listed next week, Lordship. Kindly have it on next Tuesday.
Tuesday.
By the time, my diary number also.
Tuesday. Come back on
that
Tuesday. We'll hear you.
Lordship.
Come. Jayant, Tuesday.
Yes, no problem. Let it go all together, my lord.
All matters Tuesday.
Yes.
Your Lordship, in 38, Your Lordship, it's a SLP against 37 order under the Arbitration Act rendered by the High Court. The High Court applied the principle of severability, Your Lordship. And
What is the issue?
Your Lordship, the issue is whether severability of one claim from the other when the two claims are intermingled and legally and practically inseparable, can it be done while applying the doctrine of severability?
Claims before the arbitrator.
Claims before the arbitrator.
Tell us the minimum basic facts.
Your Lordship, this is the principal core question.
Right, principle is all basic facts you tell us.
Your Lordship, yes. I'll just.
No, just 5 dates will be there. Just mention.
Yes.
Tell us what
Yes,
it is.
yes. So, Lordship, there was a MOU executed between Noida and the respondent, which is another central government undertaking for construction of a flyover.
Then?
Now, because there were some allegations regarding inflation of prices, and there were 2 reports rendered by IIT and Sowell, which said that there was exorbitant pricing. So the works were suspended. The works were suspended for a period of 928 days. Then there were negotiations between the parties, and it was decided that if there was a supplementary MOU executed between the parties where the respondent agreed unequivocally to forego claims with respect to escalation and any claim arising whatsoever.
Respondent means your client.
No, Lord.
No, Your
The
Lordship.
contractor.
The contractor, Your Lordship, which is HSCL.
You are for the Noida.
We are for Noida, Your Lordship.
Okay, they have agreed to forego.
They agreed to forego. There were 2 principal undertakings by way of 2 letters, and then they were incorporated in the supplementary MOU, which barred any claims with respect to escalation. Then, Your Lordship, after they agreed, there was no
disputes arose, they went to arbitration.
Disputes arose. After completion of work, they raised claims for price variation and claims for suspension during the suspended period. Now, what happened is the arbitrator said that the supplementary MOU was entered into through coercion and duress and set aside the supplementary MOU. Awarded claim number 1 with respect to price variation.
Despite
the supplement.
The arbitrator allowed their claim.
Allowed their claims.
Right.
With respect to both price variation as well as during the suspended period.
Then,
now the third.
It disbelieved the supplementary agreement.
Disbelieved the supplementary agreement.
On the ground that it is coercion.
There is coercion. However, the arbitrator then went ahead, Your Lordship, and said,
what happened?
In 34, the entire claim was set aside. However, the 34 court said that I have no option. He agreed that claim 2 was barred completely as per the supplementary MOU, and there was
2 arising out of supplementary agreement.
Yes.
High court, the 34 court said it's barred.
The 34 court said there was no coercion. The plea of coercion could not be proved because there was no evidence to that effect, and upheld the supplementary MOU. Said that claim number 2 could not have been granted by the arbitrator, but in principle said that claim number 1 could have been granted, but because I could not modify or sever the award has to go in its entirety. Then the matter travelled in 37 before the High Court. The High Court said that yes, the claim with respect to suspended period was a sham and an afterthought, and said that we can sever the 2 claims. So the claim with respect to price variation was upheld, and then claim number 2 with respect to the suspension period liquidated damages was severed. Your Lordship, now these 2 claim number 1 and 2, the arbitrator made 16 issues. Out of that, issue number 13 and 14 related to claim number 1 and 2. Now 13 and 14 are so interlinked and intertwined that separation of claim 2 from claim 1 is based on entirely the same set of interpretation, the same set of facts and evidence. And the
principle of law, it's permissible after the constitution.
Yes, Lord, that's absolutely, Lordship. There is no quarrel to the.
We understand your nuance. You're saying law, it's permissible.
Yes.
But in fact, they became inseparable.
It is not, because they
are inextricably connected.
Absolutely.
If one is not permissible, you can't bifurcate. The other is your argument.
Certainly, Your Lordship. And once the supplementary MOU and the
Which are those 2 claims? Which are those 2 claims?
Your Lordship, may.
So just to make it short, Lord, one is a claim for 4 lakh rupees per day for the suspension.
How much is the money? Tell us about that. What ultimately, what are you fighting for? How much?
Your Lordship, the first claim is around 20. The principal amount is, Your Lordship, 23.94 crores.
94 crores. First claim.
One minute. Claim number 3 is
1 minute. First claim 23.9. It relates to what?
price variation or escalation.
1 minute.
Yes, sorry.
Price variation.
Yes, Your Lordship.
Lordship may call it price.
So granted.
It's granted.
Price variation is.
And claim number 3, which is the interest on delayed payment of IRA third and fourth bill, is also allowed.
Interest on?
Interest on delayed payment of running account bill 3 and 4, Your Lordship.
Running account bill 3 and 4.
Yes, Your Lordship.
That's bills.
And Your Lordship, claim number 8 has also been allowed.
No, 1 minute. The first is price variation. Second is relating to interest.
No. That's issue.
Which are the two which you, according to you, are inseparable?
Your Lordship, claim number 1 is price variation. Claim number 2 is claim on account of suspension of work, which is 35.92 crores, which has been set aside by the Honorable High Court.
Suspension of work.
Yes, Your Lordship.
So now, when you are saying when suspension of work claim is set aside,
yes, Your Lordship,
there is no question of price variation in
certainly, Your Lordship.
Surviving.
Your Lordship, if no work was executed,
asking questions.
Yes, Your
Lordship. Asking you to argue. So you're saying that if suspension of work is set aside, and 34 also has set 34 is also set aside.
Set aside the award in its entirety.
And the High Court has upheld that.
The High Court has.
But then granted price variation.
Yes.
Granted price variation.
High Court saw that they are separate.
We'll come back to it. We have not
just
drawn our conclusions. There is this suspension of work one which got involved by virtue of your 22nd March 2006 supplementary agreement?
Yes, Your Lordship.
That's the one.
Claim
suspension of work is
this
the subject matter of the further novation or whatever under 22/3/2006.
Yes, certainly.
That is how you, because work was suspended, then they have entered into a further agreement, supplementary agreement.
Yes, Your Lordship.
So that suspension of work was modulated or modified by virtue of this.
Certainly, Your Lordship. Express, Your Lordship.
And the price variation claims related to which period?
Now, Your Lordship, price variation claims related to period before the commencement and after, before the suspension and after the commencement of work.
Before the suspension
and
those price variation related to those there are no additional facts in the suspension in the supplementary.
There are no
additional work in
no additional
only an
work,
extension of thing.
Yes.
Only extension of time was given. Now, Your Lordship, what is very, very peculiar is that there can be no price variation claim or escalation claim for the suspended period because it hinges on the pivotal question only when work is being executed, materials and labor is being consumed, then can a price variation or escalation clause lie. Then why would parties exclude something which did not lie in the first place? So what was excluded, in fact, was the entire claim with respect to escalation for the entire period of the contract. That is what the two letters and the supplementary MOU expressly.
Set aside with 34 and that portion is up. The supplemental MOU, arbitrator disbelieved.
Yes, Your Lordship.
Correct. 34 restored it.
34 restored it.
34 restored it.
Yes, Your Lordship.
37?
37 said, 37
Simmered,
upheld the supplementary MOU, said that claim number 1 is not barred. 37 court upheld the supplementary MOU, but said that claim number 1 can be separated from the rest of the award.
Okay, all right.
But our argument, Your Lordship, is that once the supplementary MOU is upheld, then the entire claim has to go. Claim for price variation or escalation could not have survived once the supplementary MOU is upheld. It would be an impossible interpretation of the supplementary MOU, especially with respect to the waiver in conduct and the waiver in writing given by a central government undertaking, Your Lordship.
What is the interim arrangement made in this?
No, there's a complete stay now.
There's a complete stay.
The execution proceedings are.
You haven't paid anything at all to them?
Nothing.
We haven't paid anything.
Because Lord, at that time, Constitution Bench was considering.
Your Lordship, the final bill has been paid.
Okay, what is the forget about this severability part of it. The rest of it is how much? How can you not pay that?
Your Lordship, there was a stay granted by this honorable court.
That because anyway, what's over is over. Tell us about the remaining part of it. Contentious issue, keep it aside. Remaining
Just
is how much?
working out, yes, no.
We'll ask them to pay you immediately that money.
Claim one, excluding claim one, how much is the?
Yes, yes. That you should pay. How can you not pay that?
Your Lordship, we are both government entities. Your Lordship, that is why to balance the equities.
Then don't do business. I have entered into a contract. Your contentious issue will take. To that extent, we'll grant you a stay. But remaining part of the money, pay them. How much is that?
We don't
We'll
have
pass
a
it over.
bifurcation of that. No, immediately after lunch, I'll
Give us.
But one small
You also sit down. What we will do is we'll hear you on this. On this part of it, we will grant a stay.
It's already there, Lord.
The remaining part of it, you deposit. We'll hear this matter.
Yes, but only one small factual clarification. The amount of claim one was given to us.
You are raising.
Okay.
You tell us at 2 o'clock.
Yes.
Your Lordship, may I be allowed to seek instructions on how much, if Your Lordship is inclined to direct us to pay some amount in the interim, may I take instructions on that aspect?
You don't need your instructions.
No, certainly.
We will pass order. You only have to tell us
the amount.
That particular controversial issue, how much is the amount involved? You just tell us that.
Principal amount is 23.94 crores.
That's a bookkeeped one. The Lordship is asking.
Both of you sit down and tell.
Yes,
we'll immediately
do that.
We don't want a contest.
Of course, Lord.
On this, for making an interim arrangement, we don't want a contest. You should cooperate with each other.
Yes,
tell us what's the best interim order that will inure to the benefit of both of you. You tell us and we'll fix a date.
Yes.
Thereafter, in the meanwhile, you make the payment. Come back at 2 o'clock.
Highly appreciated.
The remaining matters will come next Tuesday.
I know it is not a factual mention. Item 94, lordships are kept it for next week. So next week it should come on 10th, but 10th I have some personal difficulty.
Every matter you don't need to mention.
No.
Somebody has inconvenience, tell the court master.
Let it
will be adjourned.
Very well.
Remaining matters next Tuesday.
Yours will also next Tuesday.
Yes, sir. Remaining.
2 will come back. We are coming back for 2.
Millards, item 42, if I mention, Millards, that is a very short matter, a tender matter. You are kept
Fresh
it.
matter.
No, it's for final disposal, very short matter.
Take it up.
Your Lordships have heard it substantially. The issue is the tender.
Take it up on Tuesday. All matters will come.
Your Lordship,
May I mention item 40?
Would it be next Friday instead of Tuesday if it appears?
Your Lordship, may I mention item
online.
Item 40, Your Lordship had specifically kept it for hearing today, Your Lordship.
All right.
Next Tuesday is fine with us, Your Lordship. Actually, day after tomorrow, the NCLT is hearing that matter. Could I just request a direction for the NCLT to defer it till next Tuesday?
Will not do anything. Please don't mention the matters. All matters which are not taken up will definitely come on Tuesday. You make your arrangements. We won't work backwards, please.
Your Lordship, we are ready to argue it next Tuesday. The other side's also there. It's just that it will be civil death for the company, Your Lordship.
Please don't repeat.
Mr.
Divan, what's that?
No, I am appearing with.
All matters are coming on Tuesday.
Lordship, I keep it at 2 p.m. on Tuesday.
Then all will come. Don't worry.
Your Lordship.
Yes, but let it be Tuesday, my lord. I am opposing any interim order.
We'll reach.
Whereas I'm craving my lord's indulgence. Well, it's item 10, which my lord has adjourned to next week. All that I had told my intended to my learned friend is that is under Act X, Punjab Act. We are now applying under Haryana Act, different act. So I wanted to withdraw, but with the observation that liberty to apply there, it may be decided uninfluenced by the impugn order. I have a suggested Ballo's order with great respect and humility. I'll give a copy to my learned friend. That is under the Punjab Act so and so. We want to withdraw with the liberty to apply under Haryana Act, which will make the whole matter.
Whatever law is applicable, he can apply and accordingly it will be decided. That's all, my lord.
Dr. Singh seeks to withdraw his special.
That is the reason. No, but without that, I will be in some difficulty. So
Then we can't just come.
No, the last part was, in view of this changed legal position, the learned senior counsel seeks permission to withdraw the present SLP with liberty to file an appropriate application at an appropriate time before the concerned authority, which it may, now this last part, which it may consider uninfluenced. That's the last line, which...
Last, Dr. Singh states that appearing for the petitioner submits that in view of the above, permission granted to withdraw.
Deeply obliged. That's all I want. I'm very deeply
With
obliged.
your lordship's permission. Item 801, my lord. That is in regard to taking of the machineries, my lord. 801, my lord. I mentioned in the morning, my lord.
You have achieved what you could not have achieved otherwise, Dr. He hasn't heard because his work is over.
Sorry.
Nor has he have to give any fees to us. I said you have
otherwise achieved. Possibly fearing defeat, but also because of change of law. Both things, Whereas.
No. You are assuming that there is a fear of defeat.
No, they're only a prima facie.
Applied
Prima facie. Everything is prima facie.
If I can. 801, my lord. That is my IA, my lord. In regard to taking of the machineries, my lord. Taking of the machineries. I have moved an application, my lord.
Yeah, which item?
Today, 801, my lord. So, I just want the date, my lord, in that matter, my lord. Only IA.
We'll give a date.
Kindly give only IA, my lord. Because the difficulty, my lord, the machineries are lying there.
Your lordship, item 29. I am the petitioner. It's the entry tax, Rajasthan entry tax matter, your lordship. I am the petitioner.
Which item?
Item 29. What had happened is we were informed by the other side that the AG is not well, so they are going to take time and they were going to seek an adjournment. So my colleague had appeared online, but I believe the matter has been dismissed, your lordship. So I just wanted to, no, but your lordship, there is a problem in this because the High Court says you have not challenged the virus. The virus stands challenged in the High Court in 2016. They have not taken up that matter. So all I was requesting was remand.
In a different petition.
No, your lordship, because this came from the tribunal, I have to file all I want is this matter to be remanded and heard along with the writ petitions. Because that writ petition was anterior in time. I challenged in 2000.
It is filed by you.
Filed by me in the very same assessment year, 2 writ petitions. So your lordship can keep it tomorrow. Your lordship can keep it tomorrow. I'll just give the writ petition, even if it gets listed. Yeah, option.
I am sorry, my lord, on their appeal is listed, my lord, 18th, my lord. I'm praying for application, my lord. Please, my lord.
We list that application. Next.
Your lordship, this is tomorrow, the item 29. Obliged.
May I make a request?
38.
Item 14. In fact, I was held up in court 5, my lord. I was arguing there. I made.
On Tuesday.
My lord, your lordship, I've been pleased to dismiss it. Passover was sought, my lord.
Okay. Normally we don't dismiss. Why? What happened?
My associate had asked for, requested for a Passover. I was held up in court 5.
Friday. No, next Tuesday.
I'm sorry, my lord.
Next Tuesday.
Grateful, my lord. Grateful.
Lord, item 38, we worked out the amounts.
Claim 1, we are removed right now because that is what is the subject matter of.
Is it admitted?
Claim 2 is what has not been allowed.
No, whatever. You just
3, 4, and 5, my lord. Total works out to be a very small amount of 2.58 crores with interest as on date.
Much you take
7.75.
Okay, admitted, leave granted, appeal admitted, pending disposal of the appeal. The appellants shall pay to the respondents. Which the amount? Where is it?
7.75 crores on the extreme right.
7.75 crores.
Your lordship, may I make a request?
Correct. Why are you saying it's a small amount?
Lord, the main amount is the, Lord, for a lawyer it is a big amount, Lord. But for a party who has done the work.
7.75 crores. within a period of
Your Lordship, we may be allowed to submit deposit a bank guarantee before this.
nothing.
Your Lordship, because this
NBCC company.
if ultimately this is
So it doesn't matter within
Your Lordship,
within
Your Lordship, 8 weeks.
within 8 weeks from today.
Your Lordship, they may furnish a
Stay
they may furnish a corporate guarantee.
stay subject to
For Your
the
Lordship.
appellants paying 7.74 crores pending disposal of the appeal.
Your Lordship,
Appeal is expedited.
they may provide a corporate guarantee of the like amount. Your
These are my
Lordship.
bills which have they are not clear. This is my RA bills.
It doesn't matter.
Lordship,
We have
this is
succeeded all through. So
disposal itself instead of leave because
Lordship, it's a
it's been a
completely unsustainable.
2008 arbitration. My lord.
will be listed.
Your Lordship, one issue I wish to point out that 95.75% there was an arrangement between the respondent and a private entity. So 95.75% of this amount will go to the private entity. So once any PL that is a private entity, they are not for this court.
Of the amount will be subject to the outcome of the appeal.
Highly obliged.
Let me request for final disposal, Lord, because
No final disposal.
Lord,
We are clogged with this.
Lord, after,
This system is not working.
Lord, after succeeding in arbitration 37, my lord, we have not got anything, my lord. Any
Your arbitrations are ruling the roost. There are
Lord,
people,
that's the reason why
individuals who are
documents-
not able to get.
Lord, this is
individuals-
also
You don't want to give a speech.
because we have got counterclaims from the contractors who have done the work from us. So that interest is also right.
46? I don't want to say.
Lord, can we request for a date, my lord?
Yes, we will definitely get a date.
I am suggesting, I am fully ready to argue before the new combinations. It will take long. But Wallace, your lordship, then put a very short date if your lordship wants it to the other combination. My lord had heard me fully in 46.
Nothing.
46, your lordship had heard me fully.
Nothing.
They were to
I may
reply.
also be heard, my lordship.
That is going to be very, very problematic because benches formations are causing
Therefore,
a lot of
Wallace,
problem.
therefore,
I have to be heard in this
I
matter.
will start today, Wallace. I will continue. I will start again. No problem.
Lord, I have to be heard in this matter.
Yes, of course.
My lords heard me.
And Dr. Singhi, how
Yes,
long
my lord.
put together?
Well, I took less than 45 minutes last time. Wallace.
Yeah, we will hear him.
According to me, there is an appeal pending
No, he is, we are opposing. It's not the
before
lead.
the NCAT, in which, my lord,
It's a different matter.
Corporate
We are
sector
saying
later.
crores
he's a promoter.
have to be, my lord, added
क्या है ये?
to the total.
Hold.
Well, your lordship can actually
We are taking
give a
of the
short date.
corporate debtors.
Grant leave and gives a short date. That's what your lordship is doing in other cases. If it's an actual date, otherwise, well, your lordship then feels constrained for time because of this.
You are right.
The next matter also is the same issue.
We presented this fact by your lordship's confirmation. Your lordship directed that.
But it's all true, Mr. Niranjan. What happens is that these are all high-stake matters, and you will say 10 minutes, and then it will end
it
up
can't be
taking the
done.
whole day.
No, it can't be. Realistically, it can't be.
I'm
But
admitting it can't. But I'm only
Leave
presenting.
granted.
I
leave
stuck to
granted.
45
there
minutes
is a
last time.
problem, my lord, which we are
There's a
highlighting.
we are having.
Granting leave.
Wait till the end of, I think, in the first week of February or something.
It can, provided your lordship's my lord would have it higher up on.
What is the interim order you are asking?
My lord, there is no, my lord, express interim order your lordship's made, but your lordship directed the RP to stay his hands. So I appear for the RP. So I have stayed my hands for the last 3 years.
I have a
Happy case-
suggestion. I have a suggestion which will not harm anyone, my lord. It would balance equities.
You only have to decide a short
The
question.
matter was
Only a
heard.
minute.
Because POC has the power to.
Only a
Let
minute.
them not make a request for modification after hearing me for
I am
45
not
minutes and
allowed
dare
to
to
say
reply.
Question whether.
Dare to
I am
reply.
not requesting for a
But,
modification. What I am
according to
saying
me,
is
my
this.
lord, the
No, what I'm saying.
NCLAT,
So far, my lord,
sees of an
plans are
issue
not called for. Let
as
me,
to
I am
whether, my
listening.
lords,
Call for the plans, will not take any decision. So even if, my lord, your lordship is
This is
made to,
very
my lord, hold
unfortunate.
against us,
Very unfortunate.
that time can be saved.
Well, as my
Without,
lord hears the matter,
Equities on either side.
adjourned for no fault of ours, and he suddenly wants a modification. Well,
Half the time you are not.
my lords,
no, Wallace, I argued for 45 minutes.
There was a problem. There was
no,
a
but
I argued for 45 minutes.
there is an appeal pending
Yes,
before
hear
the
it on the first week of February or
NCLAT.
March, Wallace.
There is an appeal pending before the NCLAT.
1 minute, Mr. Venugopal will come back to.
This request, with profound respect of Mr. Venugopal, is rejected time and again.
It's okay, wait a minute.
Please give any date in first week of February, second week of February, third week, whatever suits my lord.
Rejected.
It was heard by, and please limit us to half an hour each side, Wallace. I have no problem. Please limit us each side to half an hour.
Calendar देना. कौन सा date खाली है?
Half an hour each.
I'm saying ad invitem, please limit us on time, Malas.
फुल है 24 24th है
24th.
7th April.
April?
The only date is what they say. It's all right.
Which one, Malas?
7th April.
7th April.
It's too far away.
Yes, can it be March? Is all like a request.
In the meanwhile, if your lordship
Both sides are
leave it
requesting.
at that, but if your lordship permits only inviting, doing nothing thereafter.
The matter has been heard
Why
by
should
my lord.
my lord,
Your lordship did not
inviting
accept.
invite the proposals, the plans?
This was rejected. It's orally asked 3 times. It's not fair, Malas. The lordship is asked to change your orders every time.
Including the
Not give this order.
24th नहीं.
I'm happy in February if your lordship has time until the end of February, Malas.
देखो क्या है 24th February. Okay, wait a minute. We'll just Mr. Venugopal, tell us.
Oh, for Doodh, you are for Doodh.
We know that you have some preliminary objections about the
Not preliminary objection, my lord, I'll tell you.
Whatever, please let. Yes, Mr. Venugopal.
According to me, this matter cannot be heard
Yes.
unless the NCLAT disposes of the SPI appeal.
All right, we are not hearing here. We are not hearing till. We'll take a call. In the meanwhile, we'll see what will happen.
Yeah, yes, my lord, but I must point out this
Date.
request is being made right from the beginning and being rejected.
That is correct. That is
and
correct.
matter is heard
That is correct.
time and again.
There I would agree.
Constraint, that's all. I think the issue.
Just kindly give a date in end February or March, Malas. March.
वही दे देना सर 27 February कुछ बोला
24.
हाँ कर लेना.
The week after, there's a wedding in my family.
Please put us half an hour and half an hour. Please specify it.
Together. Mr. Solicitor,
Please specify.
all put together
The 24th.
on 24th,
Could it be
2 p.m.
The wedding in my family.
1 hour. Huh?
24th February, there's a wedding in my family.
Oh.
The week after it.
Okay, ठीक है week after check कर लो. Anyway, you check it up and then we'll notify the date.
Any earliest possible date. No, we don't want.
We will check up and notify a date.
But subject to your lordship's convenience, can it be at 2 p.m. so that
Yes, 2 p.m.
it starts and it's
Till 2 p.m. We'll notify a
actual
date.
date,
Check
but-
कर लो. Check करके just show it to me, and then we will notify. We'll do it as early as possible.
Deeply grateful.
Obliged.
So first one is over. Then this takes us to
47 Malas. I have to, your lordship saw the list of dates and submissions. With
47. Also, you're there.
Yes, Malas, and your lordships heard me again, but I'll take only 20 minutes today if your lordship will permit me. List of dates and submissions. This is that matter, Malas, which I started by saying that the woes of a decree holder in India start after the date of decree. This is absolutely unconscionable, Malas. He has got a foreign creditor.
Okay, tell us just. Tell us.
Yes,
start,
very,
start,
very
don't
quick,
waste time.
very briefly. Give the list. Give the just 6-7 dates. Give the list of dates and submissions. Yeah. And I'll Malas finish in 15-20 minutes.
You know that. I remember
Your lordship
that.
has seen it. My lord, ARADHE has not seen it, but your lordship will kindly bear with me.
He will pick up in no time.
Yes. No, I appreciate it. Now, in this self-contained note,
Mr. Chidambaram will come back to you. We'll just hear him and then we'll hear you.
Yes, sir. That he's the appellant.
Yeah,
He's
we'll
opposing.
come back to you.
now let's kindly come to, in this to save time, come to 13, page 13. Kindly just focus here now. Have you given the copy? No. Now let's just very few I'll ask your lordship to take. Your lordship got it? Number 1, please tick number 1. I am a German company. As far back as 97, they defaulted for about $7 million US. I'll be very selective in the dates, fellows. My lord, ARADHE has got it?
Yes.
This is 97. And well, this is a textbook case of how not to execute a decree. I've got a decree twice over.
You straight took us to.
Well, I did, but I'm just spending 5 minutes for my lord.
No. That's the reason why I was about to tell you.
I will only give a few dates. I won't give
Take
any.
your time, please.
Then number 5, fellows. Number 5. He defaults in number 5, the other side, Mr. Chidambaram's client. On item 7, I demand the amount of 4,794,000 US dollars. This is in 2001. Note the dates, well, it's very important. Then, Malaz, in item 10, a default judgment is entered into under English law. It's very important, Malaz. The agreement is governed by English law. It gives exclusive jurisdiction of English courts, and the man has signed it, Malaz. So a default judgment is entered. Now is the interesting part. I'll just note here on the side. Item 10, the default judgment is for 5.12 million USD. And we are talking of 2003. Only 23 years ago, and starts in 97, which is Malaz 29 years ago. Then Malaz, item 14, because I knew that you will raise an objection, natural justice, this, that, I, Malaz, go and ask to set aside my judgment in my favor. That is item 14. This is something very curious. Your Lordship Malaz found it amusing last time. I wanted to place it. Item 14. Knowing how Malaz they would do in India later on. Now, Malaz, item 18, the other side, Mr. Chidambaram's client, is represented by Wild and Spade in London. They lead evidence, they participate. Your Lordship sees all the witnesses from 18, 19, 20 and on to 21. Look at the evidence led. And my Lord is not concerned. My Lord is not going behind the decree. I'm just satisfying the conscience. Then further evidence is led 22, 23, 24. So there are 7 items of evidence way back in 2005 before the English court. The current decree is passed after these 7 evidences, etc. on 25. This is the judgment decree after contest with participation with evidence of 5.8 million US dollars in 2006. Now, very important, in the middle of that item 25, no appeal is filed by him challenging the decree in England, which is where he had to. This amount is today, Malaz, 150 crores. Yes, which is the item? Well, this is interesting. This is very important. My Lord, this is what I also found amusing last time. Item 25, the boldface. It would be relevant that the judgment debtor submitted to the jurisdiction of English court and said that although it has good defenses on the merits, the default decree should not be set aside, the earlier one, because he knew he'd be able to take the objection. He said, I am saying my default decree be set aside. I'm the decree holder. He says, don't set it aside, because he knows he'll take this unfair objection here. So I got it set aside, and on evidence I did this. This statement is very important in 25. This shows the manner in which he's been playing the game, Malaz. Then, Malaz, all the objections 33, a learned single judge, Justice Muralidhar in the Delhi High Court, upholds my decree in item 33. We have reached 2013. From Malaz, the early 2000s when the decree comes. And he gives detailed findings which are there, which I'll come to in a minute. This is in item 33. Malaz, the division bench in 38 sets it aside on a very remarkably curious ground. On 44A of the CPC saying that although the pecuniary jurisdiction is Malaz of Delhi High Court, I'll just give you a second, Lord, we'll just see what happens. My Lord knows that under 44A as frozen in time, you have to go to the district court to execute. Meanwhile, our Delhi High Court changes jurisdiction pecuniary to above 2 crores. So it has to go by that change into the Delhi High Court. But 44AC is not changed. So the division bench sets aside the entire decree, saying you should have gone to district court. That's item 38. My Lord rightly reverses that in item 42 in a detailed judgment. That's 42. We have reached 2022. I had the privilege of assisting the court in 42, Malaz. Your Lordship reverses that judgment, saying that if the pecuniary jurisdiction is Delhi, then you have to go to Delhi High Court. You can't go to district court for a multi-million-dollar decree, Malaz. Then, Malaz, after the Supreme Court, I go back. So, execution is sent back. Now, Malaz, item 61, the 4 months which the Supreme Court gave, Malaz, the Supreme Court, I'm sorry, I should have just given me a minute more, Malaz. Please see 42 for a second. They said, Malaz, clearly decided on priority, decide the same on merits as expeditiously, and not later than 4 months. That's what my Lord said, because my Lord is concerned about the decree date. On item 61, the 4 months have expired in June 2022. Still no hearing. Before the division bench of Delhi High Court, Malaz, finally the judgment comes in 76. My Lord, Malaz, Justice KET and Justice Sudhir Kumar Jain set aside the learned single judge order completely. Now I'll show you what. On what? On issues of foreign malice judgment, public policy, etc. You will see. This is the whole case. Now I'm in appeal against this order, malice 76. Now come to my submissions. And Lordship will see how malice a decree holder after 25 odd years, in fact 29 years to be precise, from 97, is struggling malice to be born as far as execution is concerned in the Indian. Now come straight to malice page 4. 4 objections or 5 objections. Same bunch. Same. You haven't given submission? Submission, give the submission. Give it a copy, yeah. Give a copy, please. Objection 1 at page 4, malice.
Do it.
Beforehand. Same, na? Same. Paras are same? Pages are same. Gross abuse, malice. No, it's the same bunch at page 4. Earlier the bench heard it, so my lord has marked the earlier copy. Justice Narasimha may have marked the copy, but this is a new. This is what your lordship perhaps have marked earlier. Now let's come to objection number 1. Below para 10. It should be page 4. I'll stick to my 15 minutes.
No,
it's kindly see.
But as it is very precise always. So.
Well, this is unfortunate. Your lordship has given many judgments that a decree holder like this can't.
Old habits die
now,
hard.
kindly see this. I mean, I apart from my own case, kindly see this statement of the state of the execution. First objection.
You focus on.
Yes, just 3 or 4 minutes, just 5 minutes. First one. The decree is a summary judgment, is not a judgment on merits. Malas, forget my note.
Where are you reading?
I am answering each objection which is raised. Para 11. Page 4. Page 4, para 11. Just 4 or 5 objections. Just have objection 1. Now, Malas, forget what I have written here. My lord has seen the evidence. Is it fair to say it's not on merits?
Have you articulated somewhere the grounds on which the High Court set aside?
This is the one. First objection. First objection set aside is.
We go objection wise.
Yes, just 4 or 5 of them. First is that we, Mr. Singhvi, will reverse your decree because it's not a summary. It's a summary judgment, not on merits. Well, your lordship has to pick up that judgment and read it. Your lordship has to examine 7 witnesses. If 7 witnesses are not on merits, what is on merits, fellas? Then, in the middle of that para, impugned order in para 57 records that the witness statements were filed. It notes the witness statements. Next page, Malas 5. My lord has recorded in this Alcon judgment that you had every opportunity to cross-examine. You had opportunity to challenge. You did not do so. It's not my fault. That's the judgment. Then, Malas, para 12, judgment is conclusive. I've cited Vishwanathan versus Abdul Wajid. Right, Malas? That is the reason why. Imagine with this they are saying not on merits. Had I persisted with my default decree, what they would have argued, Malas. Now come to number 2. Natural justice is violated. Well, this has become a mantra. Para 14, detailed reasons given in the judgment of the High Court of England. At page 154, it is noted by the High Court, in response to summons, the witness statements dated so-and-so and the witness statement of Ved Prakash were filed. In para 18, the court concludes that there is no real prospective defendant successfully defending. That is why the claimant's claim against defendant should be disposed of at trial. In 19, it is noted there is no objection by the defendant to the validity of the proceedings or the application of the service. All this is recorded. I'm only on natural justice. Then, Malas, 3. It's not a competent court. Well, the English court on evidence, not a competent court. The agreement says English law and exclusive jurisdiction of English courts. What's the use of an agreement? Now, Malas, the petitioner submitted the English court was a competent court for the following reasons. A, governed by English law, pursuant to 31.2. Second, pursuant to 31.3, the respondent waived all present or future objections. But the recordal of the agreement says he will waive all objections to the jurisdiction of the English court. The respondent, having appeared in obedience to the process and having applied for leave to defend without objecting, having waived all objections, is stopped. That's your lordship judgment in Shaligram, Supreme Court judgment. Then, Malas, neutral forum in international law. It is submitted that consider a neutral forum private international law, well settled principle that by agreement parties cannot confer jurisdiction, none exists. Thus, parties to a contract, I'm reading the last 4 lines of that paragraph, can agree to have their disputes resolved by a foreign court termed as a neutral court or a court of choice. Well, if you agree to English law and English courts, you are saying that the court has no jurisdiction and you can't confer by consent. Why can't we both agree to have it's a foreign contract, Palas, transnational contract. That is your lordship's Modi entertainment. Without prejudice, this is my alternative argument, para 17. It is submitted assuming without admitting the English court had no territorial. This is their argument. Respondent waived all the objections. The respondent cannot subsequently raise an objection to jurisdiction. 21 of the CPC provides an exception as to defect. What is the prejudice, fellows? I'm asking myself.
That's why he's saying that.
Well, I can tell your lordships, foreign claimants and decree holders, they have sought opinion in writing. Shall we leave the decree and go home? In writing, that's why I'm saying so. We can have all the seminars we like, but this impression of a foreign decree holder, with a decree they wrote a sort of opinion saying that we can perhaps give it up because we can't get anywhere. Now, territorial jurisdiction in a foreign decree with an English court agreed in the agreement. Territorial jurisdiction normally lies where the cause of action arises. Where 2 courts having jurisdiction consequent upon part of the cause of action, parties by contract can vest jurisdiction in any of the competent courts by. Well, this is very clear. The agreement says so. It is submitted that English courts had jurisdiction to try the case since the cause of action arose in England. Now I'm giving you merits. Money was remitted under the loan agreement from England. This is a German company. I have nothing to do with India. The respondent at the time of obtaining the loan and several years thereafter had a duly appointed agent in England. Several correspondence were exchanged in England. Petitioner was subrogated under 16.12 of the loan agreement to the rights of the lender bank. Well, I was a guarantor kind of person. Subrogation was for that reason. I was a kind of guarantor to the loan he took. The decree holder paid the guarantee amount in London. Thus, part of the cause of action did arise in England. Objection number 4 is become in every case. Your lordship standard objection, your lordship finds in many cases. Perhaps your lordship has come across earlier ones recently. That FERA is violated. Fortunately, Indian government is fairly clear that nothing of the sort happens. Breach of FERA under section 47. The petitioner submits the decree is not based on breach of any foreign law. FERA was repealed in 1999. The sunset provision of FERA also expired in June 2000. Thus, the question of seeking any permission under 47(3) does not arise. At the time of remittance, there is no FERA. Under the new FEMA, which replaced FERA, there is no provision akin to 47(3). I hope my lord has got that. Further, the decree under question was obtained in 2006, 6 years after it was abolished. The contention that permission under 47(3)(b) is required is absolutely preposterous and ought to be rejected. Assuming without admitting any permission is required under 47, this issue is decided way back, in the 94 series of Renu Sagar. And your lordship has got Procedural. Let me put it worse. I get the decree, pay me the money, I'll be stopped at the door when RBI am taking. Let us see if RBI stops me. How does it prevent you from giving me the money? Then, further pursuant to the Master Circular of FEMA, third line of para 20, the Reserve Bank of India has granted general permission being given to a resident being a principal debtor to make payment to a person resident outside India who has met the liability under the guarantee. Therefore, the question of any permission from RBI does not arise at all. Now, I have given your lordship the circulars. I have given your lordship payment to a person resident outside India. I have given 6 circulars. I am not troubling your lordship. They are all listed with page numbers there. These are known as Master Circular. It's actually a book where you keep on adding. So it's not kind of a frozen thing. You have a loose leaf thing which you keep on adding. Therefore, the question of any permission from RBI does not arise at all. Assuming without admitting that any RBI permission is required, petitioner undertakes to obtain. How can it be his problem, Without prejudice, it is submitted the purpose of 47(3)(b) was to ensure commercial honesty. So the person reaping the benefit of a not permitted to avoid payment. Then I cite a Calcutta judgment. The court cannot allow a situation where a party can reap the benefit of a contract and not pay for it by pleading this one. Come to the next objection, 23, objection number 5. RBI's condition dated September 3 that RBI, while approving the loan agreement, imposed a condition that in case of invocation of bank guarantee, there will be no liability against the Indian company. Now, this very objection, first, is rejected by the English court in the reasoned judgment at para 18 and 19. That's point number 1. I hope my lord has got para 23 of my note. It is submitted that the conditions imposed by RBI in its letter of September 97, including the condition that in case of invocation of guarantee, no liability whatsoever will extend, were standard conditions then imposed in foreign currency loan approvals. Second, Malas. Furthermore, RBI is not a statutory bar and does not fall in the grounds mentioned in section 13. Ultimately, you are enforcing a decree. Please tell me under section 13 whether you can stop it on this ground. Without prejudice to the above, it is submitted that the aforesaid RBI condition does not restrict or negatively impact the subrogation rights contained in 16.12. The said, this clause is of our agreement, Malas. The Lordship will note it, it's at page 254 of a volume, Malas. Volume, what is volume 9 called? What is it called? 9. What? It's a compilation I filed, Malas. So the compilation volume 4 has got page 254 is their clause. 16.12, by some mistake it is not put there. My compilation, volume 4, 16.2 is there. The said subrogation clause entitles petitioner to claim the principal, interest and other amounts from respondent after I have paid the lender bank and discharged its obligation in full. Well, it's one sentence. My learned friend borrows from a bank, big amounts in 97. I become the guarantor. I pay the bank on his behalf. He doesn't pay me. I claim. I get the decree. That's the subrogation. The right of subrogation is a separate and independent right of petitioner vis-a-vis the respondent under the loan agreement. The object of the RBI condition that in case of invocation of guarantee, no liability will extend to the Indian company is to regulate and restrict the liability of respondent qua the lender bank in case the guarantee is invoked. It is not the object to deny guarantor's right to claim. Well, I am a second level person. The bank is not invoking the guarantee. I am paying the bank because you did not pay the bank. Thus, to construe the aforesaid RBI condition in the manner that no liability would incur to the respondent, that is the other side, after the guarantor has paid the guarantee amount, would not only be highly inequitable to the petitioner, but would lead to an absurd situation where the defaulter whose default has occasioned the invocation would be allowed to benefit from the default, but avoid its payment to a guarantor. Such a construction would result in denying the guarantor, that is me, Malas, contractual right under 16.12, which as I have said earlier, Malas, is at page 254 of the volume 4 of the compilation. On the basis of the loan, such a construction result in denying to me the contractual right under 16.2, which has been expressly. Now, Malas, this Shamrao judgment, your Lordship will note, where two interpretations are possible, your Lordship will not take this absurd interpretation, my humble submission to my Lord. Then, Malas, objection 6 is just ending, Malas, just a few minutes more. The decree is based on alleged breach of Companies Act. But everything is thrown as if, Malas, this has to be a challenge to the appeal in the English court. Can you raise this in the execution, Malas? You choose not to raise it in England. You're a commercial, very well, Malas, company with a lot of heft and power. You fought it in England. The decree is based on alleged breach of 194. It is submitted the decree is not based on breach of 194, 211, 215. There is no estoppel admission relating to balance sheets. If the respondent had any grievance relating to finding of fact, it ought to have filed an appeal. There is also no presumption relating to genuineness. Look at genuineness of balance sheet in execution, Malas. With great respect, Malas. Then I will leave this, Malas. Forget all that. Forget it. Now we'll just come to 28 and 29. 28 and 20.
What is in annexure here, total payable amount?
I beg your pardon?
What's the payable amount now?
Today, the amount payable is 150 crores with interest. Today. With interest, 150 roughly.
This is INR, is it? This one, total principal plus interest is INR, is it?
No, 150, 150.
121 rupees here. Where is the INR part of it?
What is the Indian rupee amount? 150 odd crores is the Indian amount, obviously in crores. INR, right?
150 crores. 135 is that INR at the bottom.
That is the 1 year ago. So with interest, it is today 150. 150.
How much was paid to you? Nothing.
Zero. In fact, he had two properties as security. One property also he got released. And the property is worthless anyway. Now, Malas, I can never recover. Now, Malas, last thing. All this balance sheet, I would call it, Malas, utter digression. 27 and 28 I have dealt with. It is not a ground which your lordship should look at. It's not a ground arising. It can't be an execution. But nevertheless, I have talked to Mr. Schmidt, the witness, and all that, just for your lordship's satisfaction of conscience. 26, 20, 27, 28, and 29 are my paras. Therefore, Maharaj, I submit, that's all. Maharaj. I stuck to my 15, 20 minutes. Well, my humble submission conclusion is this. Well, we can have all sophistry. We can have all technical arguments. What is the bottom line? Way back in 97, a German company who had relations otherwise was lured into this.
You got the point, Mr. Chidambaram. Do you have this was given to you long back. Did you prepare a counter written submission?
I've seen it last night. I'm sure it was given to my.
No, it was read. It was read over to us last time also.
I didn't appear last time.
That's anyway. Your advocate on record. Who is appearing?
No, I'm not saying that it was not given to us.
No, we are saying that it will be easier if one would give a reply to give a counter written statement in this form, written submission to this.
We have given a written submission, but if your lordships want a point by
put it in terms of this, because he has dealt with the grounds that the tribunal has taken, reply it in terms of that.
I have no objection to replying para point wise and para wise.
Go ahead. Now you start.
Well, they have filed to this very thing. They have filed on 7th of February 24. Kindly give it to my lord.
देखो इनका respondent का written submissions कहाँ है?
7th of February.
It is supposed to be a reply to mine.
But this is not a point by point.
Okay, you give one.
Point.
You give one if you can.
But I can't do it today, my lord.
I understand.
You sit down. Well, with great respect, my learned friend.
Go ahead, tell us.
He has oversimplified the matter. If I may say in a lighter vein, taking advantage of the fact that one of your lordships have heard him extensively last time. But I have to start afresh because
according to you, it is not simple but simplistic.
He is oversimplified. I didn't say simplistic, Miller. I said he's oversimplified the matter with great respect to him.
But it was dealt with in detail. Tell us.
Now, I have to start where I have to start. And I am addressing fresh arguments before two honorable judges whom I am addressing the first.
Dino.
Therefore, while my Lord Justice Narasimha cannot avoid the impression he may have created, but my respectful request is, please start with a clean slate. And
don't you ever have a doubt about that?
No, I have no doubt. That's why I said, no.
There are days when we look at the reviews every day. It's a routine. We go back and then we'll take up reviews. When we look at the reviews, we will think, oh God, why did I pass such order? We post so many matters again for hearing. So for us, there's nothing finality. In fact, that is what Jainism says. There is nothing like final. Jainism bolta hai.
The matter is more intricate and involved than my learned friend said. It raises serious questions of law, especially under FERA, Foreign Exchange Regulation Act. I'll try and go by this list of dates, which my learned friend has handed over. But I'll point out some other dates and I'll write it in my written submission. My lord, your lordship may start with 12/5/95. That's not here. 12/5/95. A German company bought into my company. I'm the JV. It was owned by one promoter family. But the German company bought into the Indian company, and the Indian company became a JV between a German company, German promoters and Indian promoters. It becomes a joint venture. Lordship may keep that in mind. And the share purchase and cooperation agreement was entered into on 12/5/95. It remains an Indian company, but it is a joint venture between a German company.
Share purchase and what other agreement?
I beg pardon?
Cooperation agreement.
Share purchase and cooperation agreement, SPCA. I first thought it was a Society for the Prevention of Cruelty to Animals. Share purchase and cooperation agreement. We'll see. We'll find out, my lord. Who is being cruel?
Canine jurisprudence.
Now, it's an Indian company, remains an Indian company, underline that, but it is a joint venture of a German foreign partner and an Indian partner. I am the majority. The 1912-96, that date is not there. JV applied to Citibank UK for a foreign currency loan. That is what is called an external commercial borrowing. Well, we are talking about 1996, when there were very strict foreign exchange control laws. In fact, FARA had come into force on 1973, and the RBI had complete control over the foreign exchange transactions. Even if you want to go abroad, you have to apply to the RBI for education, etc., etc. Very strict foreign exchange regime. That changed when FEMA replaced FARA. But we are talking about a FARA age. When we applied to the Citibank UK for a foreign currency loan, the sanction letter is at page 561. Well, I may be permitted to refer to the documents because
sanction letter of RBI.
Sanction letter received 561, no.
Okay.
This is from the government. Where is 561? 569, I'm sorry. Now kindly see, this is the letter from the Government of India, Ministry of Finance. This is not yet RBI. Now please see that.
Which are those volumes, tell?
Documents are in volume 3. Volume 3. Volume 3 is what I am told. I've been given volume 3. Volume 3. Portion.
Other than those specifically authorized and town hall.
Yeah. Now kindly see, my lord. This is the Government of India, not the RBI. RBI comes later. I'm second line. I'm directed to convey.
Formulate before you take it up. Formulate the first point on.
Formulation is that the Government of India's sanction letter and the RBI's approval letter were subject to the condition, condition reiterated more than once that no liability will fall on the Indian company and only the guarantor foreign company will bear the liability. And that is part of an order of the RBI. It's law as defined.
You get the point.
Therefore, if the Indian company is to ultimately bear a liability, it's illegal. That's my case. And when you come to execute a foreign decree, the foreign decree the foreign court said, this is law of contract is governed by the law of contract is English law. I don't recognize Indian law. And when he comes to execute it, I invoke section 13 of the CPC. And I say you can't.
That's about the judgment you're saying.
Abhipan?
That's the second argument. Okay, that will come later. But then the first argument is RBI.
Any liability foisted on an Indian company is illegal. Full stop.
You make good that argument.
I'll make good that argument. That is what I'm trying to do.
Yes.
Kindly see page 569. This is the Government of India. I am directed to convey the approval of the Government of India for your obtaining a foreign currency loan from Citibank International for financing the import of capital goods on the following terms and conditions. Then, which one? No other, paragraph 2, no other charges in foreign currency or Indian rupee other than those specifically authorized in terms of this sanction will be permitted for payment. Then kindly see 4. You are requested to obtain the approval of the Reserve Bank of India, Exchange Control Department, through your bankers under FERA in order to satisfy the Reserve Bank of India so the terms of the government approval are complied with and that no additional foreign exchange liability, either express or implied, is being assumed under the arrangements. Lord, we must not look at it from the lens of 2026. We have come a long way in liberalizing foreign exchange, but we are looking at it in the year when there was a strict foreign control, foreign exchange regulatory regime.
Yes.
Then kindly see. Kindly note that in case the credit is required to be guaranteed by a bank, development financial institution, it shall be provided by Scheduled Commercial Bank or DFI in India. The counter guarantee from a foreign bank or confirmation of a scheduled bank by a foreign bank will not be permitted under any circumstances. The guarantee issuance, however, would be subject to the authorization of the Industrial and Export Credit Department of Reserve Bank of India. Anything else? That's all. Now, after the sanction
letter is addressed to Goyal.
This is the joint venture. This is the Goyal MG Gases has now become a joint venture. I am 51 and they are 49.
No, this is addressed after it became a JV or before.
Well, the Indian company remains the Indian company. Your Lordship knows under the company law, the Indian company remains an Indian company. It was wholly owned an Indian company. When he bought in 49%, it becomes a JV, but remains an Indian company. Remains an Indian company because the company remains the same. The foreign partner has got 49%.
This letter is 1st of April 97.
This letter is 2nd April 97.
First or 2nd April.
After FERA.
1995. Okay, after 19th of December 95. 12th of May 95 is
19th of December 96 when
correct,
we applied and we asked for sanction. And this is the sanction of the GOI. Then on 24/4/97, the JV applied to the RBI because it has to get the RBI's permission also.
24th
April 97. All this is before the list of dates given by my learned friend. That's why 24th April 97, the JV applied to RBI. Now kindly see, RBI gives an approval in 2 phases, in principle approval and a final approval. The in principle approval is dated 28/5/97. 570. 570. Now, please see that RBI's in principle approval. At 571 of the documents volume, the translation is on 573. Now, let me read it, my lord, because these are 2-3 documents which are very important, which impose the condition. With reference to your application and form so and so.
1 minute, Mr. Chidambaram.
I'm sorry. This is 28/5/97.
Yes, please go ahead.
Now, please see. With reference to your application, we advise you that you have our in principle approval for raising foreign currency loan from Citibank International, London. You shall comply the terms and conditions as mentioned in the letter dated 2/4/97 of the Government of India. They refer back to the Government of India. And then 7 million is what was borrowed. $7 million was what was the application for. And then over the page, paragraph 3.3. You can execute the loan credit agreement with your lender and file with the Government of India in compliance with paragraph 7 of the letter dated 2/4/97 of Government of India. You should approach us for final approval before the due drawn of the, not due drawn, my lord. It must be drawing from the loan of credit. Due drawn is wrong. Obviously, I don't know the Hindi, my lord. I can't read the Hindi at paragraph 3. It means before drawing the loan of credit. Whatever. Before drawing from the line, it's a line of credit. You have to draw the money, but you have to approach us for final approval. 2 copies of the loan agreement duly signed by, etc., along with should be submitted by us, etc., etc. Now, this is the in principle approval. Then the loan agreement is dated 36/97. The loan agreement between the lender and the JV and the guarantor, the tripartite agreement between the lender, bank, my company, the JV, and the guarantor, which is the German partner. And that is a page. Well, it starts at page 227, but I'm not reading all of that. It starts at page 227. Now kindly come to page
227 of which volume?
Same volume, my lord. The documents are in the same volume.
234. 227 can't be the same.
Start with clause
ये first point है.
11.
थोड़ा सा time से लगेगा. These are facts not covered by. But last time ये नहीं होगा.
12.5 and 4. My lord, I'll show the clauses chronologically. 3 clauses.
That first opportunity.
So you want to start with 14.1.
You can start with 234, this will go over those riders, me and me. And then these two. The clause 11 is obviously scheduled, that will come later.
I know. Please see that starts at 227. Kindly come to 234. 234. The definition of obligers. The fourth definition, fifth definition, obligers means the borrower, that is the JV. Obligers mean the borrower, that is the JV, and the guarantor, who's a German shareholder of the JV. So both are obligers. Borrower and the guarantor. Now kindly come to clause 11. Kindly come to page 245.
You have to be little careful because
12.5.
it is very realistic and easy for the high courts in where you're going to say,
Sure.
Reference to 13 as a whole, section 13 for CPC as a whole. So you
Ah,
have
yeah.
to compare it to.
Not obvious. Doesn't look like. 234, 238, 277. What about 238? What is 238? 38 what? No, why did you say clause 11? 34 to 38 to 77. 38 is what? Down conditions. Where does it say? Then up Yes. Now kindly see 245, clause 12.5. Governing law and judgment. In any proceedings taken in its jurisdiction of incorporation in relation to this agreement, the choice of English law as the governing law of this agreement and any judgment obtained in England will be recognized, and this is the crucial word, subject in case of enforcement in India to the provisions of section 13 of the CPC. Well, he can enforce English judgment in any jurisdiction.
There's no doubt about it.
Where I have assets.
These are all
If you
admitted
want
facts.
to enforce in India, it is subject to section 13.
Undoubtedly.
Yes.
Where is the doubt about it?
No. I'm saying there was a doubt in their minds, therefore they entered into this agreement.
Or else why will they come here?
Yes. They have assets. I have the JV has assets here. Therefore they come here, but it is subject to section 13. Then kindly come to 248. Clause 14.1. Each of the obligers, the market, each of the obligers shall obtain, comply with the terms of, and do all that is necessary to maintain in full force and effect all authorizations, approvals, licenses, and consents required in or by the laws and regulations of its jurisdiction of incorporation to enable it lawfully to enter into and perform its obligations under this agreement, and to ensure the legality, validity, or enforceability or admissibility in evidence in its jurisdiction of incorporation of this agreement. Now, the JV is incorporated in India. The guarantor is incorporated in Germany. He has to ensure that German laws are complied with. The JV has to ensure that the Indian laws are complied. And the obligations are, according to Indian law, legal, valid, enforceable, and admissible in law. Then 277, isn't it? Now, this is incorporated again in the schedule to the loan agreement at 274, second schedule. Starts at 274. Which one? Now, read conditions precedent document. Kindly see item 2. A copy, certified a true copy by or on behalf of the borrower of each such law, decree, consent, license, approval, registration, or declaration, as is in the opinion of the counsel to the banks, necessary to render this agreement legal, valid, binding, and enforceable, to make this agreement admissible in evidence in each obliger's jurisdiction of incorporation, and to enable each of the obligers to perform its obligations herein. So we gave to the bank all the agreements, sanctions, in principle approval, etc., etc. So everybody was aware of the in principle approval and the sanction by the government of India. That's right. Now kindly see clause 16. Clause, we don't have to show. All right. Then the Government of India communication next is 24/7/97 at page 635. Same volume, 635. So we got a sanction letter from the Government of India, the in principle approval for what are they talking about? Yeah. Not our case. Not commenting on the council. What are we talking about? Now, 635 is important. I have 635. I've got a sanction letter and an RBI in principle approval. Now I get a Government of India letter. This is dated 24/7/97.
235.
635. 635. If I said 235, I misspoke.
No, my
635. reference is this department's sanction letter of 2nd of April 97. Then kindly see to paragraph 2. With reference to paragraph 6 of the above mentioned letter, you have furnished to this department an executed copy of the loan agreement for an amount of $7 million, which has been taken on record by this department. While the terms and conditions of our above sanctioned letter appear to have been correctly incorporated in the loan agreement, any provisions of the loan agreement which are found to be at variance with the provisions of the said sanction letter shall be void and be not binding on the Government of India or the Reserve Bank of India. The earlier letter said you must comply with the RBI's approval, and the Government of India's own letter at 569, 570, your lordships will recall, said that
Yes.
no additional foreign exchange liability is being assumed under the agreement. Your lordship recalls that. At 569, earlier letter, paragraph 4, the terms of the government approval are complied with, and no additional foreign exchange liability, either express or implied, is being assumed under the arrangements. They will only allow you to borrow $7 million, and the guarantor is guaranteeing it from Germany, and no other additional liability, foreign exchange liability, will be incurred. And any provision contrary to the sanction letter or the conditions will be void. Now, the next date is RBI's final approval, 12/8/97, at page 642. Which was now this is a final approval which spells out the conditions. Now kindly see paragraph 2, italics 1 at 642, that you shall comply strictly with all the terms and conditions as mentioned in our letter dated 28/5/97. That is the in-principle approval at page 571. And then kindly see paragraph C at page 643. This approval does not include our permission for you to make remittances automatically in respect of repayment, payment of principal, interest, and other charges connected with the loan credit. For all such remittances, you should approach us for necessary prior approval by making an application in form so and so to the concerned authorized dealer sufficiently in advance to avoid payment of additional charges by way of overdue penal interest. The application should be accompanied by Form A2, relevant documents, and no objection certificate from income tax authority. It was a very difficult time, my lord, and a difficult regulations.
Then how does, this doesn't, nothing turns on C.
No, this does.
C, what's
The loan repayment is the principal and the interest. Some part of the loan was indeed paid. 7 million was drawn, and about 2.2 million was paid regularly through this procedure. But it says this approval does not include our permission to make remittances automatically in respect of repayment, payment of principal and interest, and other charges connected with the loan credit.
Correct.
It is not any other amount except these which will be applied for and granted by the RBI. He is not asking for the loan repayment to the bank. The bank will ask me, and he as a guarantor paid the amount. Whether he is subrogated to the rights of the bank, I'll come to later. He is asking that I am obliged to pay the guaranteed amount because there was a default in the loan. The bank has collected a guarantee, as a guarantor, they have collected the balance. You pay it. That is not included in this approval. This approval is only for repayment of loan, principal, interest, and other incidental charges. And then kindly see the next paragraph, paragraph 3. The last line, non-observance of these instructions will be viewed seriously by RBI. This final approval requires time to time approval for repayment of, then come to 640, no, 2150, JV letter to RBI seeking clearance of guarantee. You have to show that, no?
And then they say 642 also, that as regards the issue.
I'm coming.
Legal advice you said.
647 will come.
642.
And guarantees kept open at clause 7. The next three documents are important. Now, the same document, the last clause, 6.4, the final approval permits
This would have been met.
remittance for the loan.
What is the next document?
Same document, clause 7 at 644. As regards issue of guarantee, we shall be advising you separately in due course.
इसके पीछे लगा
644.
इसके 7 पे भी 3-4 पेपर लगा 640.
The same document, last clause at 644. So this approval is not for the guarantees. This approval is only following the earlier in principle approval on the Government of India sanction to borrow a loan. And this is to repayment of the principal, interest and incidental charges. And even that you should apply time to time, and there's no automatic approval. The guarantee was kept open. RBI had not approved the guarantee. He offered to the bank, naturally required a guarantee. He offered to make the guarantee, offered to give the guarantee, but that was issued, was kept open by the bank. Now, at 2150, your Lordship may not worry about looking at the document. On 2897, the JV wrote to the RBI seeking clearance of the guarantee. That's a fact. That is answered at page 647. Same volume.
What is 28? What is the date? 28?
20th August 97, the JV wrote to the RBI, this issue of guarantee is still open. Please approve the guarantee. That we wrote to the RBI, that is at page 2150, but your Lordship need not look at the document because the answer is on 3997 at page 647. 647.
647.
This was the first submission I made. I'm leading to that, and I've shown the documents for the first submission. It's a short letter, but according to me, crucial to the case. I read the whole letter. Issuance of guarantee. We invite a reference to our final approval dated 12/8/97 and advise that you have our permission for issuance of guarantee by your foreign collaborator, Messrs. Gresham GmbH, that is the petitioner, for securing your foreign currency loan of $7 million obtained from Citibank International, subject to the following terms and conditions. Condition 1, there is no outgo of foreign exchange by way of any fee, direct or indirect, for the proposed guarantee. No money should go out of India. 2, in case of invocation of guarantee, no liability whatsoever will extend to the Indian company. It is the guarantor's liability. You can't fasten it on the Indian company. This is the condition under which the guarantee was approved. I am the Indian company. My original promoters are shareholders. The German promoters are shareholders. The German shareholders are coming forward to guarantee the Citibank London. You may give the guarantee, but no money should go out of India for the guarantee. And if the invocation of guarantee will not cast any liability on the Indian company.
Got the point.
He is saying, sum and substance of his argument is, I have paid the guarantee, you pay it. But it's he is fastening the liability on the Indian company. This is contrary to the permission granted for the giving of the guarantee. And if the guarantee had not been given, maybe Citibank would not have given a loan. I don't know. They may have given a loan, they may have, but the guarantee, he is not suing on the loan. The loan has been repaid, the bank is not chasing me. He is saying, the guarantee has been invoked by the bank. I have paid the guarantee. Now you pay, you reimburse.
Law prohibits is what you say.
No words can be plainer. In case of invocation of guarantee, no liability whatsoever will extend to the Indian company. The English court says, I'm not concerned with Indian law.
Where is that portion you show?
I'll show, come to that, Miller. I'll come to that. Your Lordship will allow me a little time to come to that. Now kindly see the loan agreement. I showed your Lordship the loan. Millard, I'll show what this order is traceable to in law. It's traceable to section 8 and 9 of the FERA. That is one. And then the loan agreement, which I showed to your Lordships at page.
Traceable to 8 and 9, right?
Section 8 and 9. I'll read FERA in a moment, but I'll complete this argument. The loan agreement is dated 3697. That starts at page 234. Loan agreement starts at page 227. Now kindly come to 16.2, clause 16.2 of the loan agreement. 16.12. 16.12. 16.12 at 254, he claims subrogation. There is this case. His case against me is that he has fulfilled the invocation of guarantee and he is subrogated to the bank's rights. Now please see, 254, 16.12. When the guarantor has met its obligations.
1 minute. Yes, right.
When the guarantor has met its obligations in full under this guarantee and indemnity, it shall be subrogated to the rights under this agreement of the banks, and the agent, my lord, is defined as the bank's agent. Your Lordship may ignore that. Under this agreement of the banks and agent against borrower. If the bank has any claim against the borrower, he is subrogated because he has fulfilled he has paid the guarantee amount. If the bank, but the bank has not asked me, the bank has not acquired any rights after the guarantee has been invoked and the guarantee amount has been paid. The bank has not asked me or fastened any liability on me. So what is he subrogated for? What is the subrogation? If the bank has a right against me, he is certainly subrogated. But the bank has not asserted any right against me because its loan has been repaid by the guarantor. That's one. Secondly, by virtue of the subrogation or prior to the subrogation, if the bank had proceeded against the Indian company, it would be void under the final approval. The bank cannot proceed against the Indian company because it will be fastening a liability on the Indian company. That is void under the approval 39.
What's the remedy for them? What is the remedy then?
Who?
How
Sorry.
how will they recover?
Who will recover, my lord? The guarantor. Guarantor can't recover for me. He gave a guarantee.
What's the avenue? What's the avenue?
He can't recover against the Indian company.
That we understand, but we are asking. So therefore, there is a prohibition in it. He should not have met the light.
Should not have
In the light of
this
your argument is in the light of
not have given a
who asked them to
guarantee
do it.
with the condition that no liability can be passed on the Indian company. He should have said, I'm sorry, I can't give this guarantee. And he should have renegotiated with the bank. Having given this condition, having accepted this condition, he should not have given a guarantee if he wanted to. If he intended to proceed against the Indian company, he should not have given the guarantee. This open eyes, he gave the guarantee.
All right, it's not.
And this loan agreement, I'm attacking it on two grounds. One, he is not subrogated to the rights of the bank because the bank has not asserted any rights against the Indian company. The bank must have a right against the Indian company and he can be subrogated. But the bank has not asserted any right against the Indian company, number one. Number two, if he gave the guarantee.
But that was done because of your default, right?
Not our, I mean, it is the Indian companies.
JVs, what is you say?
JV paid 2.2 million. There's a balance of 4.8 million. The bank should proceed against the Indian company if it wants. But the procedure against the guarantor, because he gave a guarantee. Well, in all the guarantees, you do a guarantee, you give a guarantee in the hope that the principal borrower will not.
What is the nature of business of these companies?
Abhipana?
What is the business of these companies?
Oh, they are a very large manufacturer of air separation units. Air separation units are installed in steel plants and other plants. Air separation units, air liquid, which is bottom. The German company is changed hands, Miller. The German company is changed hands. It's an air liquid with a French company. Industrial gases.
Goel gases. His name is Goel gases. He doesn't do that much, but that's what is.
No.
Company.
Oil
That's why he
gases
tried
is a large gas supply company in India. Air Liquid is also a very large company in the world. These air separation
companies.
Company is
doing well.
there. Goel Gases is there. Lordship will see trucks with Goel Gases. Next time you travel by road, if you can. Goel Gases is a established company. But we are talking about a regime 50 years ago.
The point.
But when I went abroad, I had to go to the chief controller of foreign exchange, beg for $7.50 a day. I'm sure he had a more liberal regime. More liberal regime. I had $7.50 per day for 10 months a year.
We had a lovely.
I asked him, Mr. Atma Ramarao, I asked him, he's a fine gentleman. He gave me an appointment in Bombay. I was barely 20.
That was when you were going abroad, is it?
When I was 20. And I said, I've got admission, you give me. Why do you want to go abroad? You study in India. I said, I've got admission and then I want to go. He said he will give you only $7.50. But 10 months, I asked him in my enthusiasm, what do I do for the 2 months? How do I live? He says, that's for you to decide. This includes dormitory, food, personal expenses like toiletry. Everything is under $7.50 a day. Tuition will be given separately. This is $7.50 a day. Therefore, it's a very different regime, my lord.
Well, it's when my father went abroad, he had to save on the very limited foreign exchange allowance, much more limited than even what my learned friend is saying, by taking a ship, because the airline, they're all separately categorized, how you're traveling, how much will you spend tuition. So the airline would not want to fit within the budget. So you had to take a ship in the 50s, that is early, middle 50s, not too long ago. Whereas when I went, the great liberalization we used to all cherish is the so-called TR, transfer of residence. Because you could get these absolute sin items like a car, like well, it's all these even expensive television sets. It's a and whereas the TR would allow it to come at 0 or as personal effects. Otherwise, the car had about 200% duty minus. So that was a very cherished thing, the TR.
Today we have come to LRS,
Yes.
Liberal Remittance Scheme. Every year you can send out about 1 lakh, 1.5 crore. 1.5 crore can be remitted abroad for any purpose. Therefore, we've traveled the wrong way, but
Really
can't look at this case
sending the tuition
today's
fees
lens.
to my daughter at Imperial.
Yeah.
Now it is so easy.
Yes, it's just to go to the bank and fill the LRS form, and then they will remit it. Therefore, it's a very different regime. Therefore, we are not judging the conditions. You're not passing a judgment on whether the condition is valid or not. This condition was imposed. This condition was imposed, which clearly said if the invocation, if the guarantee is invoked, no liability will fall on an Indian company.
Your whole argument is that all this was done keeping your eyes open.
Yes.
And even though the liability was mine and I had deliberately defaulted, I'm putting it like that. I'm putting it as a provocative statement. Deliberately I have defaulted, knowing fully well that this clause will be, the legal regime is in such a way that you could
only
no way recover from me. I defaulted. What is it that you can do now? Show me.
The bank can only proceed against the guarantor. But please remember that he had 2 directors on my board, 3 directors on the board later. He fully participated. He had a resident director, Mr. Schmidt. He attended every board meeting, every AGM meeting. Therefore, he was fully participating in the management. It was a truly joint venture.
Tell us when the decision was taken by the guarantor to pay the money.
Yes.
Were there any correspondence in between, so far as the JV is concerned, that anything which would say that the liability will be taken over at a later point of time by the JV?
I have correspondence immediately thereafter when the JV was requested to pay the guarantee charges and the JV refused, citing this condition.
Before they paid, we are asking, not after they paid.
I can find out when they paid. I don't have instructions at the moment. I can find out when they paid. But shortly after, this RBI permitted furnishing of guarantee with the condition that liability will not be passed on to an Indian company. They asked me to pay the guarantee charges. I pointed out the charges cannot be passed on to the Indian company. You have to pay the charges. I refused it and he accepted it. He didn't protest against the refusal of charges.
Got it. Go ahead, Mr. Suman.
Now, I'll continue. No, maybe we'll come to that.
Is he time?
Well, 1612, I pointed out two grounds on which I attacked 1612. 1612, he did not subrogate to any rights of the bank because the bank asserted no rights against the JV, number 1. Number 2, if he claimed that by virtue of clause 1612, he has a right to invoke, right to recover the guarantee amount from the joint venture, that is a violation of the condition of the final approval. The third is, that's the second ground. It's void under the RBI's permission as well as the Government of India's letter. Now, my lord, now kindly see page 589. What is 17?
Page
589.
ये 3 points क्या होगा? 1, 2, 3. So to guarantee charges from us,
No, no,
put
no.
in 98 itself that we will not pay because of this omission. 1702 says we can show first. That
No,
comes
no.
prior in time.
No, no, we'll show that. 589 and 590, no? 589.
Not segregated to the rights of the bank because bank did not respect any right against the Indian. Second one, was conditional is provided under the no condition.
1902. So take that volume.
As early as in 98, much before the guarantee was invoked, we told them you're not going to pay anything. And they never
No,
remitted
no.
us.
589 in June 2000. Now please see 589. As you may know, we have to charge a guarantee fee for all guarantees issued by Messrs. Gresham, since we are not allowed to treat subsidiaries different from third parties. This results from tax reasons in Germany. For the years 1998 and 1999, these fees have mistakenly not been charged. We will book these fees this year and at the same time waive the payments. However, you will receive debit notes for the amounts due in 2000. The fee amounts to 0.25% per annum of the guaranteed amount and will be charged by the corporate office semi-annually. Please take this into account when you prepare your financial statements and your planning for the year. I answered immediately over the page. Refer email dated 30/6/2000. I answered the next day. In the loan agreement executed with Citibank International for sanction of ECB of $7 million, no provision was made for any guarantee charges. On the basis of these agreements, approvals were taken by the Ministry of Finance and the Reserve Bank of India. The Reserve Bank of India, by their letter dated, etc., granted the approval to the loan subject to the following conditions. There is no outgo of foreign exchange by way of any fee, direct or indirect, for the proposed guarantee. In case of invocation of guarantee, no liability whatsoever will extend to the Indian company. A photocopy of the letter dated 3/9/97 of the Reserve Bank of India is enclosed herewith for ready reference. In view of the above stated limitation, it will not be possible for the company to make provision and remit any guarantee commission of the ECB from Citibank. So we pointed out to him straight away, no charges can be paid. And if you invoke the guarantee, no liability can be fastened upon the Indian company. Also kindly see in this connection 1702. This is in volume 3, documents continuation, 170T.
Does the GV agreement, the JV agreement
Yes.
between you and the German company talk about the loan aspect of it and the liability with respect to the loan? Does that
Both
agreement?
of us oblige us to the bank. The loan agreement is with the bank.
Bank, true, but then apportionment or the liability is not spoken in the.
There's no, both of are jointly liable because we are the borrower is the Indian company, as the guarantor is the German borrower is the Indian JV, and the
So
guarantor.
to the extent of your obligation to pay the loan, the
JV is primarily liable to pay the loan because the borrower is the
JV's
JV.
liability is shared equally.
No, I'm not splitting
I'm
the liability.
probe further.
Yes.
Yeah, we are
Please,
splitting. You may
please.
not be. But then the liability or liabilities that acquired by JV are to be shared is the
No, my lord.
MOU between you?
No,
You two?
there's no MOU between us.
The JV agreement itself.
Borrower is the JV. It's a legal entity. You can't, it's not a partnership, my lord. It's not a mere partnership where the partners are liable in proportion to their capital. It's a joint venture company. It's a limited company. And then
What are the profits of the JV shared?
profits of the shares are dividend 49% and 51% according to the shareholding. If he sells some shares, if I sell some shares, the third shareholder will get the dividend.
The inter se relationship is governed by only the JV agreement?
Only the JV agreement?
Tripartite agreement.
No. JV agreement is a bipartite agreement.
No, that's a,
The loan agreement is a tripartite.
I'm not talking about the loan. JV. Inter se relationship is only through JV?
Only the JV, share purchase and cooperation agreement. That is the JV agreement.
Where is the JV?
It's there in page 451.
Okay, you don't need to show it. Show us that now.
I'm completing this
Complete.
guarantee
Yes.
at 1702. This is dated 1st July 98, shortly after the RBI permits furnishing of guarantee subject to the conditions. 3997. That is my main argument is 3997 and the twin conditions. Now, this is shortly after that, about 3 months, 4 months, or 10 months, Guarantee Commission. With reference to your email dated 19 June 98, regarding the above, we would like to draw your kind attention to the loan agreement had with Citibank International for sanction of ECB. According to that, there was no stipulation for payment of any guarantee charges. On the basis of this loan agreement and the terms and conditions agreed with the lender, the Ministry of Finance have given their final approval dated 12/8/97 and by their letter dated, etc. The above sanction is subject to clause number 1 of the said amendment, which reads as follows. There is no outgo of foreign exchange by way of fee, direct or indirect, for the proposed guarantee. A copy of the amendment is enclosed for your reference. Hence, it will not be possible for us at this stage to accept a guarantee commission of 0.25%. This is repeated in 589 and 590. This letter of July 1 was not rebutted at all. In 98 and in 589, your Lordship will recall, 589 and 590 are dated June 2000. 2 years later, they claimed a fee and we refused it, and there's no rebuttal of that. So in both in 1998 and 2000, it was pointed out to him that no guarantee charges or fees can be claimed for me. And in case the guarantee is invoked, no liability can be fastened on the Indian company. It was clear, my lord. Now, my learned friend's list of dates, I'm sure he's pointed out,
nothing of this
starts with the subsequent developments.
Yes, it's no reference to.
It does not contain all this. I'll put it in the list of dates and my.
You will refer to all these in your list.
I'll refer to all the list of dates and the
Please
page.
do that.
I'll do that. Now, my lord, we start after he invoked the guarantee. The guarantee was invoked. Your Lordship may note the dates. I'll put it in the written submission. The guarantee was invoked on 8/10/2001 and paid on the same day.
Govind date.
and it was paid on the same day by the SLP petitioner, 8/10/2001. Fully knowing that the guarantee is invoked, cannot be fastened on the Indian company. He paid 4.8 million US dollars. 2.2 had been repaid. The balance was 4.8 million. He paid. No quarrel.
But those dates, last of the dates which he said.
You issued a notice, is it? You issued a notice for what?
But they write down exactly a week later.
27/4. Where is that? No, what is this? 27/4/2001 legal notice.
Yes.
When did they write to you?
We wrote for it.
No, no. No, no, you want me to read it? You want me to read it?
Kapil?
When did he issue a notice?
What?
15th October. Where is that? My lord, he paid the guarantee amount on 8/10/2001 and on 15/10/2001 at page 305. 15/10/2001 at 305. 1 week later, he writes a letter. This is the beginning of the dispute.
I think it will merge now with his letters.
I beg pardon?
With his dates now, it will merge thereafter.
Yes.
1 week later, the letter is written. What is the date of that letter?
October 15, 2001.
Yeah, that he has it at serial number 7.
Yes, he has it. He has it. Serial number 6 and 7.
Yes.
He paid the guarantee amount and then he writes a letter. Now,
So 9/10 he pays.
I thought at 8th of October, but he says
9 he paid.
It doesn't matter, my lord. 8th or 9th doesn't matter.
Citibank, it is recovered from him. We marked it.
No, no, no.
To Mesa.
Let's read it. When? After that.
Before that. 22/7. चलिए साहब उतना बड़ा स्लो है 22/7/2001
My lord, before this letter from the petitioner upon the JV at page 305, I had written a letter to the Citibank on 22/9/2001, which is at page 287. Wait. 287 may be read first and 305 may be read later. 287 is 22nd September 2001. This was reference to your letter dated 4th September, having reference number. You are aware that the loan was availed by us for acquisition of capital equipment for various projects, and we have utilized the funds accordingly. At the time of granting the loan, Messrs. Gresham had assured you that they are our technical and financial collaborator, and they will provide all the cooperation, technical and in other matters, to successfully implement all the projects. Accordingly, Messer had guaranteed the loan. Only on these assurance, we had planned and funded the projects out of the funds obtained from you. However, in breach of all their assurances and obligations, Messer did not cooperate with us and rather created problems in implementing the projects. Due to this non-cooperation of Messer, almost all the projects which have inter alia been funded from the loan availed from you are not yielding expected generation of funds. Despite all these, we have paid 2 installments of the loan. Additionally, we have a claim of Indian rupees 5 billion against Messer on account of breach of certain clauses of our share purchase and cooperation agreement with Messer, but Messer has failed to make the payment. In view of the above, we request you to recover your entire outstanding term loan, including interest due from Messer as it has guaranteed the loan. And this is copy marked to Messer. Disputes arose, my lord, between the parties.
Why didn't you caution them?
I beg your pardon?
You didn't say anything like the agreements prohibit recovery from
No, I didn't say
guaranteed
that.
money,
I
nothing
didn't
like
say that, but you will recover from them because they are aware of the agreement. They are aware of the sanction and approval and conditions. And
Alright.
then he
Then-
writes to me at 305.
He could have objected and not paid the guarantee.
No, it's all
Later
right.
you object.
I marked a copy to him. The bank should recover from the guarantor and not from the Indian company. 305. His letter, we are in receipt of a copy of the letter dated September 22. That is my letter from P.K. Gupta to Citibank in connection with the repayment of the term loan taken by GMG pursuant to loan agreement, etc. Among GMG as a borrower, Messrs. Gresham as guarantor, Citibank as a lender. We are shocked to read the contents of your aforesaid letter, which are not only factually incorrect, but demonstrate a total lack of bona fides. The term loan of $7 million was taken from Citibank by GMG, and therefore the primary obligation to repay the said loan, along with interest thereon, is on GMG and not on Messer. The fact that Messer has guaranteed the loan does not absolve GMG from its primary contractual obligation to repay the loan. GMG's allegation in the aforesaid letter that Messer, in breach of all their assurances and obligations, did not cooperate and instead created problems is not only incorrect but false. Indeed, the facts are to the contrary. Additionally, it needs to be emphasized that the loan was not granted for any specific project. The loan agreement also does not contain any assurance or other obligation on the part of Messer regarding any project. Well, the usual allegations against him, his allegations against me, that when fighting partners fight against us, they will make allegations. Besides, there is no reason for GMG to commit a default when it is financially able to meet its contractual obligation. Then he says, I'm a profitable company, etc. On account, the middle paragraph, on account of GMG's default, that is JV's default, in honoring its repayment obligations to Citibank, Citibank has invoked Messer's guarantee $7 million on 1810. In view of the encashment of the Messer's guarantee, Messer was subrogated to the rights of Citibank under the terms of the loan agreement. Accordingly, Messer demands from GMG a sum of so and so, 4.8 million, etc., under along with default interest under paragraph 17.2, etc., etc. So this is the two partners fell out because the JV did paid 2 installments, did not pay the third installment. Bank pressed us to pay, and then after some time, the bank invoked the bank guarantee. The bank guarantee was paid. Now, I don't agree, and I've submitted already. He is not subrogating to any rights of the bank because the bank has not asserted any rights against me. Bank has not claimed against for me. Bank has
It
not
was
filed a
using for
suit
that.
against
The whole purpose of having a guarantee from an entity
Yes.
outside India, because
Just cover the bank.
overseas borrower or
Yes.
overseas creditors, for them easier because
To recover from the guarantee.
but for that they could not have granted loan and they are easily accessible. So therefore he invoked and then recovered. So far the bank is concerned.
Correct. That's why in 50 years ago, when foreign banks lent to an Indian company, they did not lend without a guarantor.
Correct.
Because they know the foreign exchange laws and the foreign exchange regime, that you have to go to every dollar, every rupee, you have to go to the government of India and the RBI. And a loan of 4.8 million, there's no question of recovering from an Indian company. It's very rarely would the government of India give permission for a defaulted loan.
Every Indian company took advantage of that.
Yes. Indian company, my lord, I wouldn't say that, with great respect to your lordship. I wouldn't say that.
No, we won't say every company. It's
There was
possible.
no other way an Indian company could get a cheap loan, because the interest rates were then 15%, 20%.
There for us.
Therefore, the way
Not
to
only
get
the
cheap
not
finance
only the
is to
interest,
borrow.
but also the
For
quantity.
example, Tatas would have assets abroad, they can borrow. But an Indian company, Goel Gases, who knows it in London, it can't borrow. It has to have a partner. That's why all the earlier collaborations are with English companies.
But this
German
paragraph, the
companies,
top
Japanese
paragraph, the
companies.
first paragraph at page
Yes.
309,
Yes.
which you skipped, is it's an
309.
important paragraph to show. First
306,
paragraph,
my lord.
306 top.
Yes.
Read that.
Yes. Besides, there is no reason for GMG to commit a default under the loan agreement. That is his view, Miller.
Read.
Yes. When it is financially able to meet its contractual obligations. The balance sheet of GMG shows the net current assets of GMG as on the date as 137 million rupees. The aggregate loans taken by GMG are 337 million rupees, and GMG is reserves and surplus aggregating to 1,928 million. Notwithstanding the fact that GMG had sufficient funds, GMG defaulted in making payment of the installment of US dollars 1,284, etc. US dollars so and so, principal plus USD, which was due and payable to Citibank. That is his version, Mullah.
Your Lordship,
His version.
incomplete document. The correct document is the page 172. The page is missing in that.
No, I apologize for that, but
It's told.
tell me which page is missing.
172.
I'll produce that.
Yes.
Tomorrow we have. Tomorrow is a part heard matter.
When?
The broken. Nothing happens like this.
Tomorrow is final hearing day.
Friday to
No.
Tuesday, let's secure papers.
Well, tomorrow is final hearing days. Wednesday. Next Tuesday.
2 o'clock.
Next Tuesday.
This is a big problem.
Item 49, could it be
Lordship,
week after next?
Lordship,
Tuesday
Dr.
of
Singh
week.
is not available next Tuesday. Can it be on 17th?
It's up to you whether he will do or you will do. I mean, we can't keep on. It's impossible for us to find dates.
Oh, different.
Impossible for us to do that.
Whenever your lordship keeps it.
Tuesday we will sit.
Tuesday.
There's no way.
49, not next week, Tuesday week.
Which one?
Item 49.
Whatever. Yeah.
Tuesday week,
I'm requesting any day before Saturday.
We will see. I don't think it will reach because this matter is going to be next Tuesday. We'll complete this.
Yes, sir.
Mr. Chidambaram, another half an hour.
Another.
Yeah, you should be taking
45 minutes. I'll complete.
All right.
The main argument is done.
Yeah, this is your sheet anchor of your argument.
Sheet anchor is 3997 and the conditions, twin conditions in 3997.
Equities is not something, we are troubled by that. We're just flagging it to you, flagging it for you to address that. Technically, legally speaking, yes, it is there. But then where does the entirety of the loan you have taken, JV has enjoyed, whether it is shared and half of it, has it been taken away by the German company? So we don't really know, but it appears as if you have to address us on that question. Okay?
Well,
Not on the list. Come back to us.
I agree.
We don't take a
Hold on
final
to what
call.
the
You come
lordship
back to
says.
us.
legally, am I liable to an English default?
What we deal with is law
summary
and justice. So it's not just
I
law.
agree, but there's a
Okay, we will see.
summary judgment of an English
We will have to.
executed in India.
You have a strong point there. But
My learned friend wants on 24th instead of 17th. I have no
like
problem.
even these are all 2 p.m. If other matters get over, we'll take it up. So there's nothing like a reservation.
Not next week.
Yeah, not next week.
Obligement.
After it also, we look at